I have informed the other side for you.
Forty-eight and 49. No,
48.
okay, we'll take it up when at 2.
Well, this matter, my lord was pleased to hear this matter first time. This matter went to Justice Soyab Jahan Bala. Then the matter went to Justice only Krishnan Bala. Then
We'll take it up at 2.
where my lord?
2 o'clock.
With the consent of the other side, Lordship, I beg to mention item number 29, Lordship. This matter, similar Lordship. So, I'd like to pray to that matter along with 5228 of 2020, Lordship. Here the petitioners are the project affected Lordship of Lower Popeni Hydroelectric Project, ATG.
The request of the Standing Council of the Party Autonomous Council, the matter stands adjourned to be listed again on 3rd of August 2026. Along with
5228 of 22. Okay.
In item number 13, madam, respondent number 6 had died, which came to our knowledge when the meter last listed, madam. We have filed an IA yesterday, madam. Definitely call
item 30,
13, 1, 3,
1-3.
1.
Who died?
Respondent number 6, madam.
None. It has been submitted by so and so the learned counsel appearing on behalf of the petitioner that on account of the death of the respondent number 3, an interlocutory application has been filed for substitution of the legal representatives of the respondent number 3.
6, madam. 6.
Respondent number 6 or 2?
6, 6.
6. Accordingly, list this matter on 5th of August 2026 along with the state interlocutory.
Can it be on 11th, madam? My senior will appear, madam. For disposal.
For interlocutory application, you require senior.
No, madam. Possibly records have also come.
Huh?
Records have also come, madam. May I dispose it of?
No. On 6th, 5th. You see then.
Tablet.
Concept of the other sir, I break you. I wasted in the time. It is not in the record. So we break
They filed the compliance affidavit. All for that. Why? Will be called for. Go rush with this slip and get it.
I beg to mention that.
Item number
10, Your Lordship.
Ah.
Your Lordship, as my senior is suffering from severe diarrhea. So, Mera kindly be adjourned for today.
Item number 10.
Yes, 10, my lord. On behalf of B and
Why the matter has come up? It has come up for orders. We'll see when the matter reaches.
Make clear. Regarding item number 11, Lordship, with the consent of all the parties, this clarification matter, Lordship, it was agreed that all matters have been had together, Lordship. We have filed affidavit, Lordship, already.
We'll see when item number 11 is taken. Stay vacant.
Lord. অনেক কিছু হিসাব করছি
Now it is 13,78,000. You got the particulars?
My lord, the last time we have given, my lord, my friend, my lord,
I'm asking about whether have you got the particulars? Who
Yes,
is
yes.
entitled to the amount?
yes, ma'am. Power of attorney, then all these certificates, yeah, necessary
Show me.
certificate.
Hey, where are your bank details? Where are your bank details?
Yeah, last page, my lord. The Mrs. Pegu, Rita Pegu. The Mandiramanta has died. I have given it death certificate.
And your power of attorney is defective. Are you not aware? When a power of attorney is given, the attorney has to be accepted. Are you not aware? Is this the power of attorney you make it? Where is the acceptance of the power of attorney by the attorney holder?
My lord, that is Rita Pegu.
Huh?
Her signature is necessary.
Absolutely. Where is it?
Now, she has come.
No. My question is where in the power of attorney the signature of power of attorney is there?
But that is acceptance by the.
How? How?
But your lordship is correct.
I'm correct. That is why your power of attorney is defective. You can read it.
I will give it.
It seems that you are not helping the cause.
No, no.
You can come.
No, my lord, I will.
No. You are not serious about your case.
Sorry, I'm sorry.
No, Mr. Saikia, this is absolutely. First of all, you have made the power of attorney on 18/6, meaning thereby you have not submitted this particular document earlier.
No, yeah,
Then if you have submitted, then why you are making a fresh power of attorney?
No, my lord, because of course, the power, NOC was given, my lord, kindly
No,
see.
forget about the NOC. I am asking you why you are making a power of attorney on 18/6/2026 after the order being passed. And on the other hand, you have made a categorical submission on the last date
Yes.
that you have already submitted those documents.
NOC,
This document has come into existence subsequently.
no, that as per their order, see letter, we have submitted the NOC, my lord. Kindly see, I have.
And this power of attorney is defective. Can there be a power of attorney without the signature of the attorney holder saying that I accept the power of attorney?
That is lordship, only because power of attorney question came day before yesterday, but we have submitted the NOC. Lordship, they have got it long back.
When did it come?
I am-
Day
I am-
before yesterday.
My lord.
They have asked for what are the documents they have asked for?
Here, my lord, this is the letter. As per letter, we have submitted all those things. Long back.
Death certificate of late Prabhat so and so. Next of the kin certificate, legal heirs, bank account number of the petitioners. Why you are not submitting the bank account numbers of the petitioners?
Petition. Petition too. Yes. No, petitioner no.
You have to submit the bank account number of every person.
Every person. No.
Absolutely, it is given with S, not petitioner, petitioners.
My lord, kindly see the letter, their letter, Lord.
Their letter only.
Their
That is
letter,
7/10/2025. Read that.
their letter was, my lord, kindly see, my letter at 10/3/26.
I'm not on that. I'm asking you kindly see their letter of 7/10. Ekon ঘূৰাই দিয়ক। 7/10/2025.
7/10/26. Yes, yes. We have given they asked the bank account number of the, to whom we have.
Kindly see. Death certificate of Prabhat Chandra Mohanto. There's no quarrel with that.
Yes,
Because of the fact that this court have already permitted the substitution. Next of the kin certificate is already there.
my lord.
Bank accounts of the petitioners.
I thought that it was a,
Though it is clearly mentioned.
my lord, petitioners, I thought that is their typing mistake. Yes, yes.
No,
They are.
absolutely no. It has to go to each and everything. It will be apportioned into 4 parts. There are 4 persons, 4 parts. It will be given to them. Then letter of NOC to make payment through one petitioner.
We have
That
given,
NOC is being given to the
Yes.
REIA.
yes, my lord.
So then you have given this document.
Yes, I have given to them. And you see, then my lord, here death certificate, then my lord, next skin certificate, then account number of Simti Rita because they asked that only if you give the NOC, we will give you that check to the NOC holder.
Where is the NOC?
NOC we have submitted to
You
them.
have a copy of it.
Yes, we have submitted to them, my lord, long back. Finally, see 10/3/26, and before that also, we have given it. There is a letter, Lord, see. The letter, Henderson, see you. There I got additional,
You do one thing. Mr. Sakya,
my lord.
you do one thing. Get in that power of attorney, which is you are having it. Get it signed out there. You have that Rita Pegu. Get her signature out there.
She is there, man. My lord,
Get her
nurse,
signature out there as down below as accepted.
my lord,
I accept. Then she put her signature.
my lord.
We'll take it up at 2. And then you give the proper documents and get better documents of that bank account. I also can't see it. Tomorrow you may come up with this aspect. Okay, 2 o'clock. Then I will give it to them, and by after vacation, I'm fixing it on 15th of July. In the meantime, the payment be accorded to this account.
My lord, one prayer, my lord, kindly see the order of the honorable court. What is it? Order to this one? No. Lekhiya na pass karna.
What order?
My lord, the order passed by the reference court at paragraph 7, page 27 of my contempt petition. Contempt there.
Yes. What does it say?
My lord, that paragraph 7.
Yes.
Dear Lord Chief, yes, in case number 16092, PW Babasandra Mahanta, that the value of the land and dealers will be rupees 5,75,000, but he has been awarded by the collector rupees 39,000 for the land and rupees 1,73,659.
No, that we are not concerned. We are
No, no.
concerned with, Mr. Sakya, kindly come to page 23.
Yes, that is your, yes.
We are not on the, I'm not
Yes.
sitting on appeal against that.
Paragraph 21, my lord.
Paragraph 21.
My lord.
No, paragraph 20.
20,
As discussed above,
yes, my
the
lord.
compensation for the land is awarded at rupees 2 lakhs
Yes,
per
ma'am.
kotha for
Yes.
acquired land. And
Number-
increased compensation for the Jirat at 50% more to the compensation awarded for Jirat by the collector is awarded.
So,
Further, the parties will get additional compensation of 30 and so and so. Now for Jirat, they have already given the compensation, they have put it at the value of the land. This is 12 lakhs of land. Isn't it?
my lord,
12.5 lakhs of land.
my lord,
So they have put it at
1,73,659 for Gilead was given by the collector. And 50% of that amount should be given by them.
so therefore they have put it out there.
I have calculated.
No, kindly see. and increase compensation for the Girard at 50% more to
Who?
the compensation awarded for the Girards by the collector.
The collector,
Now,
collector
how much will
awarded
the
rupees 1
collector
lakh,
give?
collector awarded rupees 1,73,659, my lord.
Where?
My lord, paragraph 7 of this, at page 20, rupees 1,70,659 for Girads. They have awarded, collector awarded this amount for the Girad, that is for the demolition of the building. Half of that, 50% would have been given by the honorable reference court. 1,73,659 divided by 2, it will come to rupees 86,829, my lord. I have calculated this paper.
You have calculated?
And that on that account, I have calculated myself. So, actually, no? 16, 1,000. itu balik ke tempat 86 tau.
No, I tell you why. You see, the total compensation which was worked out for Prabhat Chandra Mohanrao was rupees 1,70,127.
What are Jiria?
No, not by acquired properties. Given for an account of his acquired properties, which is 1,70,000. Kindly come to page 18.
For Jiras, it is
No, no, not Zirat. You say that look here, the value of the land should be not 1,25,000, but the land value should be 2 lakhs. Kindly see page 18, paragraph 3. See, pity down below. Mr. Gugoi, have you seen it? Petitioner Prabhat Chandra Das in reference claims compensation of the acquired land measuring 12.5 acres covered by KP Patra number so and so at the rate of 12 lakhs per katha, which will amount to rupees 1,25,000,
Yes.
and compensation for the building as described in Schedule B of the petition amounting to rupees 4,24,710, and the compensation for the Girard described in the schedule of the petitioner amounting to rupees 27,000. The total amount of claims so made by Prabhat Chandra Mohanrao was rupees 5,76,710. Now, how does the court look into it? The court passes an order. As discussed above, the compensation for the land is awarded at rupees 2 lakhs per katha for the acquired land, which comes to 1,25,000 to be the value of the land, 12 lessons.
Malum.
And increased compensation for Girard at 50% more to the compensation awarded for Girard by the collector is awarded. Now, what they have done is they have put the Girard as per the court order as 61,130.
Malum.
Now, 61,130 plus the amount which have been mentioned in so this is so therefore they have put the additional compensation at rupees 1,86,130. This is the additional compensation. You are getting a compensation in terms with section 28.
Well.
So therefore, once you get that compensation, then on that amount, you are getting 30% of the additional compensation
Well,
and 12% for the year on this amount for the period from 11/10/2019-89 to this. This is only on the additional compensation.
Right.
As regards the other compensation, you have already received 80%
well,
under with protest. Okay. Now, total amount column 7 point so and so is demand.
Uh.
Already paid by BC Kamrup is rupees 39,050.
well,
Now, what is this 39,050 paid? Because here he says that he has received 1,70,127. Huh? We do one thing. This order was passed in 2001.
well.
In fact, this, you should have gone for execution before the executing court. Why are you here? Why are you filing a writ petition?
My lord,
Do you think the writ petition, the writ petition or contempt should be used for the purpose of this?
no, my lord, the ground has been there in the petition, my lord.
No.
That was petition was allowed,
So what? The court should not have allowed.
but because what I have,
Anyways, besides the point, let us not go into that. You take this amount of money,
my lord,
and if you have anything, go before the reference court.
and I'm obliged to your lordship.
Yes.
Not
Take
on the
this
written
money.
paper is there. I will obtain that signature.
You get the AR at 2 o'clock. We'll have the matter at 2 o'clock. In the meantime, you get that and get better copies of that particular bank account and provide ask her to get the original bank
I
account.
will bring the passbook
Bring the passport
of Rita
and get it certified and give it to him.
Rita paper I will bring, my lord. Rita paper.
Only Rita paper.
Yeah. Obliged.
So you come up with that.
Obliged.
But this type of reputation should not have been entertained at all. Anyway, they can't say without the final request I have paying them. Final request I have paying. What is this?
Here, my lord. The page 51 and 52, my lord.
What are you challenging? Why the matter has come up?
But the
As per
respondent, my lord,
direction of
8
the
has
court, the
been-
matter has been listed today and 19/6. So and so do this matter today under the order column for dismissal. In view of the fact that on the last occasion there was no representation on behalf when the matter was heard. However, also no probable is present. This will include present. Released to me. Yes, now what is this?
We have at the 2 health center and 1 school, my lord, is situated in our village.
Service is complete.
Response number 8 has been expired, my lord, but we are not present.
Word on it. Yes.
The response number 8 has expired.
Then what to do? What is your case?
Here are the 3 institutes, my lord,
Huh?
here are 3 institutes are located in our village, my lord. But the nomenclature of the institute, my lord, is in the name of other villages, my lord. Our prayer is to, my lord, to change the nomenclature and it has to be named in our village, my lord.
Who are you?
But we are the, my lord, villagers, my lord.
So what?
Page 51 and
Go
52.
before the civil court, not
I'll
here.
say for a moment, ma'am, 51 and 52, ma'am, there is a request being made by the page 51 and 52. A deputy commissioner to the director of health center and director of
Anyways, what do you want to do? To change the place name of Sri Soilendra
Putra Hazara is the
Kumar Dr. High School, Gulamati, and substitute by Kudro Hazara. so that the same name shall be known as Soilendra via. Okay, so you change the name of Bhulumati.
Yes.
Now, this cannot happen without the Home Department, Home Ministry being present. It is only they can do. The petition is in fact. And file this and go and file suit, not here. How will you know whether it is Kudra Hazara or Bhulmati?
On the page 48,
Why?
there is a report of the circle officer.
So circle officer can say so.
Yes, madam. Because the.
Then go before you have a good case, go before the civil court. Not here. Not here.
The responses come from the.
Deputy report in connection with the petition of Corona Kanto Deka. Who is it?
He is the president of the Putraja village.
Then,
Page 40, kindly see, but.
and as per the report of investigation of AI situated on so and so village and so and so, so and so, so and so. Village and Bulmati. Many central and so and so are situated over the land measuring so and so here. Yes, what is your stand?
Our stand is Lordship may kindly come to page 51 and 52. This is the letter written by the District Commissioner, Deputy Commissioner to the Director of Elementary Education. Last but two paragraphs.
Requesting the changing the name of Lamati Hensel High School and to according to the committee, the above mentioned three are situated in Kudra Hazarika. Connection so and so is clearly mentioned that it's been constituted to the different. So what happened there?
Same letter, Lordship, the Deputy Director of Health Services, next page.
Then why you're not taking action? Elementary. Who? Your part? Fantastic. So do it. Why have you not changed the name of the school? Health. Why you are putting it Bhulamati? Why you are not considering the letter dated 28/11/2019 submitted by the Deputy Commissioner? You get your instructions. We don't require number 8. Why do you need a dead person? Fight along with him. The issue involved in the instant proceeding is the non-consideration of a public petition filed by the villagers of Kudra Hazara village for change of the name of the health sub-center, high school, as well as the Ayurvedic hospital from Lahati Health Sub-Center, Soilendra Kumar Dr. High School, Lahati, and Lahati Ayurvedic Hospital to Kudra Hazara Health Sub-Center, Soilendra Kumar Dr. High School, Kudra Hazara, and Kudra Hazara Ayurvedic Hospital. It is also seen that the Deputy Commissioner Kamrup Amingao had duly certified that these health centers as well as the school are situated at Kudra Hazara village. And in spite of that, the Education Department as well as the Health Department of the Government of Assam have not taken any steps for due correction. Under such circumstances, this court therefore directs the Director of Elementary Education Department as well as the Director of Health Services, who have been issued communications dated 28/11/2019 by the Deputy Commissioner Kamrup Amingam to place on record the reasons why the said communication issued by the Deputy Commissioner Kamrup Amingam have not yet been acted upon. List this matter again on 7th of August 2026 for admission. Service complete.
Service complete, madam.
Okay, service being complete, list the matter for admission on urgency, no urgency. No urgency.
Not so.
On 9th of September 2026. What is this? Service complete?
No.
Huh?
Petitions were filed here.
To file appropriate application for striking out the name of respondent number 5, 6, 8, and 18. See, you want to strike out their name?
Yes, sir.
Okay. Mr. Ardhor, the learned counsel, appearing on behalf of the petitioner, submits that the names of the respondent number 5, 6, 8,
And 18.
and 18 be struck off. Full stop. Taking into account the above, comma, the names of the respondent numbers 5, 6, 8, and 18 are struck off at the risk of the petitioner. Full stop. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry shall make necessary changes to the cause title as well as update the same in the CIS. So list the matter for admission on 14th of September
Can it be
2020.
on August, sir? Because
August. Okay, 26th of August 2020.
like
26.
The order of this past honorable court has been complied with manner.
Complied?
Complied with manner. I'll show manner from the record manner. They kindly come to.
They have not complied with the order. They have not complied with the order. They have referred to another document which your lordship has considered, and your lordship held that despite this document, they are liable to pay. And they are not paying, saying that we are referring to that document. That kind of engineering code or violence they are paying.
My lordship may kindly come to page 2099. The order, the relevant portion of the order.
Yeah.
Where it, madam. Therefore, to court, therefore, of the opinion that the petitioner having the entitled to his PVC claim in terms of the contract and GST paid by the petitioner from its credit ledger. But credit ledger has to be taken into consideration while computing the PVC claim of the petitioner. The petitioner would be well advised therefore to take steps in terms of the period 29/1/2020 for making its PVC claim, if not already done, and respondent railway shall pay PVC claims on the basis of the contract. It is yet again reiterated that on the ground that the petitioner had paid the output tax to electric credit ledger by using its input tax credit to save amount of ground code, uniting settlement of the petitioner to reimbursement of GST. The said exercise of PVC bills, the petitioner will completed within 1 month of the date is certified for. Now, as per JPO dated 29/1/2010 or 21. Now, lots of the time we come to my effect. Case number 303.
30.
302.
Yes.
Well, this is the PVC bill they have submitted. On the right hand side, column, this is the PVC claim against the PVC bills.
Then
And middle column is the PVC, the differential amount, and the right hand side column, the CST claim amount. Lots of we previously paid without paying the GST amount. Now, we have paid this amount, the GST calculation.
how much?
Kindly see, 17.
Page, how much you have paid?
303,
Huh?
303, next page.
Ah.
17 crore 27 6 lakhs 27.
You paid?
Madam?
You paid it?
My lord, yes, my lord, we have paid, man.
You have
This
paid
is the first-
17 lakhs.
No, my lord, 17 crore, man.
17 crores you have paid.
Paid, man.
Where is that?
My lord. My lord, we have given it, my lord, they have admitted there.
You got that?
My lord, 17 crore, you have said.
This is totally misleading.
My
man.
lord,
I just-
my lord,
No, no, okay, where's your statement that you have paid?
My lord. My lord, pair of nine. Three, man, pair of three.
What is annexure 2?
My lord, annexer. My lord, that is the next bill they have, my lord, submitted regarding GST, my lord. My lord, why, my lord, we have.
You have paid that 17 crores.
Yes, my lord.
Reduce the amount comes to human total savings with the expense of self-declaration provided a certificate from the EIs. Para 5.
Three, pair of three.
And so on, has been paid to the petitioner on the PBC 6 and to PBC on 22/1 to year. The PBC for the period when has been paid to the petitioner, which was accepted by the petitioner without any protest in here. And so once again, range 4 being for which is under process. So when did they raise these bills?
My lord, please.
On 5/10/2024.
Yes, my
What is the date of my order?
5/12/2023, madam, lordship may kindly see.
No, where is my order?
My lord, order is, my lord, is,
My judgment is what date?
my lord, please, I, 178, madam.
26
No, no.
June.
This is, you have done, we close it now. If you have any grievance out there, the law, you go before arbitration, do whatever you feel like. This court cannot look into.
My lord, how is
This
it, my lord?
implicated on Hurt
Let me-
Mr. D.
let-
Mojumdar.
let pointer man.
No, no, absolutely no.
My lord, this is
No.
correct. My lord, lordship will kindly
No,
see.
no, I am not. You have any claims more than that?
No,
You
no,
ha-
no, my lord. My lord,
Have you
lordship
got
will-
this
my lord,
17
lordship will
crores
give
or
me
no?
1
My,
minute.
my question is, have you got that 17 crores or not?
My lord, this is different bill, CC bill. This is not the bill. Lordship directed us to raise a bill. We raised a bill of 29A. We have filed a specific reply to this paragraph. The
What do you say?
29A bill is not mentioned here.
The payment of refund made is towards the GST utilization claim of the PD accordingly not in pursuance at all in pursuance and in terms of the judgment of the year so and so. In other words, the subject payment referred
I have-
to in the paragraphs under reply is in respect to PBC area which were raised towards the PBC claims, but only included the price component and not the tax component as per the request of the year. It was only after the judgment date is so and so. The petitioner has raised claims towards the differential amount of tax payment by PBC
29A.
bill number so and so by Annexure 6 series to E in terms of the judgment and order aforesaid, whereby the petitioners were directed to the payment of the tax component under the PBC so and so. As a result, the payment of the made by has nothing to do with the PBC claim under the PBC clause in respect of the differential amount of tax and the taxes under the opinion to mention the entire dispute which was involved in respect to the differential amount of the Where is your PVC bill?
Yes.
My lord, in my petition, lordship kindly.
Annexure 6 series where?
Yes.
Huh? No, this what? 213,
211.
213,
Oh, my lord, yes, 211, madam.
211. So they have claimed 13 crores and all,
Yes.
isn't it?
And our bill number is 29A. In
29.
their affidavit, they do not speak about these bills.
Okay, let us see what do they say in the plan.
My lord, their first response is page 276. Two 276, madam. 276. Legal opinion has also been received to comply the honorable court order by later under reference. It has also been discussed with the law officer and he advised to comply with the order. Therefore, kindly suggest further course of action. This is page 26, 276, ma'am. They've returned the bill, madam, page 286. Page 286. They have returned this bill, which we have submitted pursuant to lordship judgment, page 286. In reference to page 286. In reference, last paragraph, in reference to the above subject matter, it is to inform you that your PVC bill number 29A, which I have just referred, amounting to rupees 13 crore 84 lakh 64,000, etc., submitted on 26/7/2003, pursuant to the Honorable High Court order dated so and so, in case of such, has been returned by the associate finance with observation by PP3 of the case file, copy enclosed. Therefore, you are requested to comply the finance observation and submit the compliance to the.
What is that?
That also is here. 289, madam.
Huh?
289. That observation.
PP3.
Yes, ma'am.
What is that?
289.
The undersigned has also. What is it? To accounts wide letter dated. Have you not typed it out? Huh? 288? Yeah, 289, PP3. Kindly refer to this office letter dated on the subject, which is placed that the party concerned has not yet submitted their claim for GST under GST neutralization, which is available at pursuant. The same will be settled as per the Honorable High Court's order dated so and so. The said letter was issued with the approval of the further PVC bill needs to be submitted in terms with the extent guidelines given by the Railway Board dated so and so. Then what have you done pursuant to this?
Lordship, kindly see the next page, page 290, the same document 24/2/2021, which your lordship has discussed in paragraph, at page 187.
Then
187. On the basis of this document, they cannot deprive us. There is no. Then they say that, and they have filed an appeal because there is a instruction to file appeal, page 293.
who?
293.
What happened in the
They
appeal?
There is a delay has not been controlled, appeal has not been till date. They have clearly said we will not pay the bill, and now they are misleading some court, my lord.
But why you are misleading the court? Why
Absolutely
haven't you
misleading.
mentioned about this 20?
29A is the bill which we raised pursuant to your lordship judgment. And they refer to some other bill and say we have paid. That is
This is
the CC
misleading.
bill.
No, madam. Madam, I'll
It's
explain,
very
madam.
unfortunate.
Mr.
matter.
Goswami,
Madam.
Mr. Goswami, we will hear the contempt now. We are not going to hear to anybody else. We will hear this Mahabir Singh.
Madam.
Let him come. No, let
Just
him come
for my-
before. Absolutely, let him come. I am not going to be misled by you. You are trying to mislead this court. Yes, when the bill is 29A, why you are mentioning about all these things?
I mean, 29A bill, madam.
I think I should refer you to the bar council. You are not fit to practice. Absolutely. No, you have misled this court. No, absolutely no. Where is the bill pertaining to 29A? Where have you mentioned about 29A?
Madam,
No, nothing to it.
30 seconds, madam.
No, 30 seconds is over.
Madam, 30 seconds.
You tried to mislead this court. Misleading this court would not help you out.
Madam, I may be allowed to explain. madam.
Absolutely no
Madam,
more.
kindly come to page 237.
Where have you mentioned that you have
Madam,
paid?
kindly come to 237, my lord. Kindly come to page 237, my lord. My lord, they have calculated as per your own formula, my lord.
I'm not on that. You should have said, yes, upon calculation, they are entitled to this and we have paid them. Where is it? As per 29A. I'm not saying. Mr. Goswami, kindly listen. If they ask for 1 crore, you may very well say, as per your calculation, it is 20 lakhs. I will say it to be complied with, so that they can fight it out as regards the other aspect. But when you are trying to mislead this court by saying that all these bills have been paid from 6 to 29 and all these things, but there is no reference to the bill number 29A, it is absolutely misleading.
20 now.
Mr. Goswami, I don't want to hear you.
1 minute.
Mr. H. Gupta, no, I don't want to hear you. You are not fit to practice in my court. No, sorry. You are misleading this court. Why on earth did you make that statement before this court? On the first occasion, you said that the payment has been made. Where is the payment pertaining to 29A? You should have said, Yes, 29A is no bill at all. This has been wrongly given. We have paid
Yes.
against that amount, 29A. We have, where is that statement in your affidavit?
Well-
Where is your statement in your affidavit? And you are saying that we have made the payment? No. Okay, 1 minute.
One
Okay.
minute, my lord, kindly come to page.
I 1 minute explain.
My lord,
I'm asking, giving you an.
29
No, Mr. Goswami.
Yes, my lord, I'm 29.
Explain it.
29A, my lord.
Yes.
29A, my lord, they have, my lord, calculated as per your own formula, my lord. So, well, the lordship direction is not for a payment of in the basis of the old formula. My lord.
Where is your statement that 29A has been wrongly calculated?
My lord, that is not, my lord. That
Then
is not.
why on earth did you make that statement before this court that 6 to 29 has been paid and others we are taking into consideration?
This is a wrong
But
calculation. Well,
where is your mention out here in
that
affidavit?
that is a mistake, my
I
lord.
don't think we should appear any further in this matter.
My lord,
You
kindly
should-
see, my lord,
No.
29.
I'm think that I'll refer you to the bar council. Let the bar council. No, bar council has to take an action against.
Is it, my lord?
No, this is not an instruction. I would have understood. Yes, instruction may be wrong. I don't have that instruction. But making a statement before this court that you have complied with it, I was about to close the contempt
No, no,
application.
no, no,
Yes,
I'm coming to 237. My lord, kindly see.
I'm not on that.
My lord, kindly see 237. My lord, I am not, my lord, interested to mislead the court. My lord.
No, you are trying to mislead.
No, my lord, kindly see, my lord, 237.
Kola kita bot lekin. Like,
My lord, I apologize. My lord.
no, you are put in the black without notice.
My lord,
Blacklisted.
my lord,
You are
Act 2, my lord, I am
blacklisted
giving
before
instruction,
this
my lord.
court.
Act 2, my lord. Act
No.
2, my lord.
I am not on. You are blacklisted before me. Any further.
My lord, my
Because
lord.
you have tried to mislead this. Making it very clear.
My lord,
Very clear,
my lord,
Mr.
10 minutes, my lord.
Mr. Goswami. My question is, why on earth did you mention it first? Yes, you should have said, okay, 29A is the bill. There's no mention out there. My lord, we are going to, we'll file an alia. There is a reply, more particularly when they.
My lord, I am not
No,
paralyzed,
Mr.
my lord.
Goswami.
This is a, my lord,
When
also-
they have filed a reply there against and said that 29A have not been made the payment, then also you make a statement before this court, or have you not read the affidavit in
my lord,
reply?
I am sorry, my lord. I am sorry.
No, there is no sorry
I'm
about
sorry.
this. This is a very
Then, my lord, I
serious
am sorry, my lord.
infraction.
Then I
on
am
you.
sorry, my lord. That is my mistake, my lord.
This
But
is
my
not
lord,
your mistake. Your
kindly see,
mistake,
I have not
your
pronounced
mistake
reply, my
is,
lord.
your mistake is that officer. Let us get hold of that officer.
My lord, I'll-
We'll get hold of
Tomorrow,
that.
my lord. Day after tomorrow, my lord.
Why?
My lord, Lordship, may kindly see this, my lord.
Why he wants to be inside the jail for filing a false statement. From here directly to
My lord, I am talking, my lord.
central government people, where do they? Railway jail. Railway jail? Here. Railway platform, this fellow. Because of you. Because of you, this particular person is going to suffer. Don't try to play with this court, Mr. Goswami. And I know about this matter. From the first day, you have been unnecessarily making these arguments. In this case, you made the arguments unnecessarily. You tried to confuse this court in this matter, right, left, and center. I remember this matter,
I apologize.
but this is not the way. You should not identify yourself with the client. Now, as I am looking out here, I think you should put up your gown out there and sit out there as this Mahavir Singh. You have identified yourself with your Mahavir Singh. Are you a lawyer of the court or not? Are you an officer of the court or not?
Excellent.
Then you have to point it out. Yes, 29A. Yes, you may very well tomorrow categorically say that 29A bill we have looked into, he is
Yes,
not
sir.
entitled.
That is my mistake.
That's it.
That is my mistake. Yes, ma'am. I
But
apologize.
you say that you have made the payment. Don't come up with this type. I don't think you should. Mr. H. Gupta, you take over the reins from Mr. Goswami in this matter. I don't want to him in this matter any further. You should not appear in this matter. You have now tried to identify yourself with the client. Yes, Mr. Goswami, I don't know for what reason you are trying to identify. Is it because of the fact that you don't have any matters out there for any other matter? Or is this the only matter out there? I don't know. But don't identify yourself with the client in this matter any further.
I'll an affidavit of me.
No. You are not going to file any further. Mr. Gupta, you appear in this matter any further. No more of his appearance. Really, Mr. Goswami, I have considered you in high regard. The high regard which was there, which was plus 20, now it has gone to minus 50. This is your standard in the practice now. In my court, court number 10. And this court I'm going to remember till I'm there in this court. Take it up. Next time onwards, whenever you make a statement, I'll never believe you. I will say it WA. And I will ask your client to be present out here in all matters to come up and say that yes, because I will never trust you. Very difficult to trust. Heard Mr. Dilip Mojumdar, the learned senior counsel, assisted by Mr. A. Batra, the learned counsel, appearing on behalf of the petition. Mr. G. Goswami appears on behalf of the respondent number. All respondents? There are 3. You even don't know how in the petition how many.
Murthy Roy, Meena, and Mahavir.
Who appears for Manoj Kumar Meena?
Murthy, Meena, and Mahavir, we have brought notice, this is the notice. Who are the 2? Yes. So this is the full notice, this is the fire.
None necessary. Appears on behalf of respondent number 1 and 2. None appears for respondent number 3. None appears for respondent number 3. The petitioners herein have approached this court alleging willful and deliberate violation to the judgment and order passed by this court dated 26/6/2023 in WPC number 2683/2021. For the purpose of understanding the said dispute, this court finds it relevant to quote paragraph number 41, 42, and 44 of the said judgment passed by this court. From the above quoted paragraph, this court had clearly mentioned as to how the PVC claim is to be worked out. And with a specific observation that the GST paid by the petitioner from its electronic ledger, credit ledger, has to be taken into consideration while computing the PVC claim of the petitioner. In pursuance thereto, the petitioner submitted the PVC claim on 11/7/2023 of an amount of rupees 13 crores 84 lakhs 64,524. It is very pertinent to take note of the PBC claim number, in as much as the respondents have tried to mislead this court by way of their show cause notice. The PBC claim number was claim 29 capital A. Subsequent to the submission of the said PBC claim number 29A, legal opinion was sought for by the respondent number 3. Taking into account that the respondents concerned have not taken any steps in that regard, the instant contempt application was filed. The record reveals that an affidavit was filed by the respondent number 2, wherein it is categorically mentioned that the petitioner was paid an amount of rupees 17 crores 26 lakhs 27,382.25 towards the PBC 6 to PBC 29 on 22/1/2024. Further to that, for the period from 31/10/2017 to 1/8/2023, it is mentioned that the PBC claim have been paid to the petitioner, which was accepted by the petitioner without any protest. Further to that, it is mentioned that the petitioner once again raised 4 bills with respect to GST on PBC as PBC 30 to PBC 33 for an amount of rupees 3 crores 36 lakhs 97,505.86 on 5/10/2024, which is under process. At paragraph number 6 of the said affidavit, it has been mentioned by the respondent number 2 that a judgment and order dated 26/6/2023 passed in WPC number 2683 of 2023 have already been implemented immediately on receipt of the PBC claim of the petitioner as per the JPO dated so and so, and hence prayed that the contempt petition be closed. It is, however, very pertinent to mention that from the enclosures, to the said affidavit, More particularly, Annexure 1, signed by the senior AFA. What is AFA? Mr. Gupta, what is AFA? Eastern Financial Advisor. Senior AFA.
Associate. The associate finance advisor.
From the enclosures which have been mentioned. There is no mention of the PPC bill number, claim number 29A. Mr. Dilip Majumdar, why the A is put in your annexures with hand?
In the deal itself,
Or A, the word A is not, cannot be typewritten.
why exactly when they wanted to file the submit the bill, there they found the bill number 29 already there, so it was made with the name.
You could have made any other thing. Why did you make it 29A?
30 to 33 already submitted without
You
text.
can make it 55 also. Why did you put 29? And why did you put A everywhere? By hand. What is the bill number? What is the bill
Lordship will find that
communication
page-
number?
Page 213.
Now kindly come to this particular document which your charter accountant had given through
Page
302. Now kindly see your 302 document. This is your charter accountant. Huh? 302. Is it your charter accountant or not?
Yes, yes.
Then why there is no mention of this document? What is the date of 5/12/2023? Okay.
This document.
Why there is no mention of this 29A in his PVC bills?
Twenty-nine A was the differential amount. 29 bill number 29A was only for the differential amounts percent to your lordship.
Understood. Why there is no mention?
This is
The charter accountant has not given this because they have asked from you a charter accountant certificate. Why there is not a single certificate to the show about the 29A?
well, page lordship kindly say 212 in my petition. That is the bill.
No, I am not on that bill. Your bill, what is the date of the bill?
Date.
Huh?
Well, page 211 what will find. bill.
Understood. What is the date of the number of the bill? Every bill has a number. Kindly see to page 305 and 306. Every bill has a number. Bill CC, this is current account. What is CC bill?
Current
These are not PBC bills.
No, man, this is current contract.
Where is that bill of this 13
29A.
crores? By your certified, by your, yeah. How did you find out this amount? PBC?
Page 211 and 212, madam. Full chart is given, 213, total calculation is given. From
And what is this 212? Why it is signed by some officials of the area?
receiving, they have received.
You are saying that 3 persons are received.
Three stages, three different stages.
How did you get this document?
We got received from.
How? If it is received by 3 different stages, means it is an internal document. How did you get this?
Our, the letter start from page 211.
These are all signed by all these officials, meaning that, what do you mean by these officials?
211 is also signed by the railway.
And then
Page 211 is our.
all these documents are being signed. Now, why all these 3 persons are signing it? Why there is no acknowledgement of why there is no acknowledgement of receipt of bill number, PVC bill number 29A in any of your documents?
29A is start from 212.
Understood. Why there is no receipt, any document which shows that there is a receipt of the bill 29A?
Page 286. 86.
2,
86.
yes. Ah, okay.
29A.
Okay. 1-8. Kill to?
Railway.
Huh? There is no reference to the PVC bill number 29A. However, from the communication issued by the respondent number 3 herein to the petitioner on 1/8/2023, there is a specific reference to the PVC bill number 29A. It is also relevant to take note of that the petitioner thereupon filed an affidavit in reply stating inter alia that the information which is being the averment so made in the affidavit was completely misleading, taking into account that there is no reference to the payment of the PVC bill number 29A, which is the subject matter, which is the bill submitted in pursuance to the directions passed by this court in the judgment and order dated so and so, passed in WPC number so and so. Next. In spite of the said aspect being very clear, when the matter was being taken up, Mr. G. Goswami, the learned counsel appearing on behalf of the respondent number 1 and 2, stated that the petitioner, the judgment and order passed by this court had been duly complied with, as the petitioner herein was paid the entire amount. And in that regard, he referred to the affidavit filed by the respondent number 2, and more particularly to paragraph number 3, 4, and 5, and 6. The said submission made by the learned counsel appearing on behalf of the respondent number 1 and 2 disappoints this court at the conduct of the council. Inasmuch as the council could have very well, after taking into account the affidavit in reply filed by the petitioner, submitted before this court that he would obtain instruction as regards the payment towards bill number, PVC bill number 2829A, which was the bill in pursuance to the judgment and order passed by this court. However, it was not expected of a counsel of Mr. G. Goswami's stature to inform this court that the payments have all been made. It is a settled principle of law that a learned counsel of the court who appears in the court appears as an officer of the court. And for the sake of his client, the said lawyer, the advocate, the learned counsel should not identify himself with his client. However, taking into account that this is the first mistake committed by Mr. G. Goswami, the learned counsel, this court is not inclined to take a serious step against him. Be that as it may, it appears that the respondent numbers 1, 2, and 3 have taken this court for a ride. The respondents, and more particularly the respondent number 2, have taken this court for a ride. By stating that the amount have been duly paid, that the judgment and order passed by this court have been implemented. Accordingly, list this matter again on 15th of July 2026. An opportunity is granted to the respondent numbers 1 and 2. Whether that GM is their party or not. The general manager of NF Railway, we have not. We bring him also, draw contempt against him also. Because he is officials, he is responsible for that.
Finally, he's there.
Because it is under his aegis this has happened.
William Pittman.
So we initiate contempt against him also. This way. The respondent numbers 1, 2, and 3. Respondent number 1 shall file an affidavit clarifying as to whether the PVC bill number 29A have been taken into consideration and acted upon in pursuance to the directions passed by this court in the judgment and order dated so and so. List accordingly.
Respondents, more particularly the respondent number 6, Secretary Revenue, North Coastal Hills Autonomous Council, is directed to pass appropriate orders on the representation dated 4/1/24 filed by the writ petitioner number 1, and if the balance 14 bighas of land belonging to the petitioner number 2 and 3 are not found to be utilized for the project or any other alternative project or even required, then the petitioner number 2 and 3 should be permitted through right of use and cultivation over the said land as landholders. However, if the land is found to be utilized either by the North Coastal Hills Autonomous Council or
any other APGCL project.
You are appearing for?
The address of container number 2.2. MD APGCL.
Who is it?
Managing Director of APGCL. Although Lordship is currently not holding the post, Lordship. Is currently not holding the post, Lordship. With the people we have, Lordship.
No, my question is different on another aspect. How APDCL or North Kachar Hills can be using a plot of land if it has been acquired? And if it is not acquired, it has to be acquired. Isn't
They say that out of the 25 bighas of land, they have not acquired 14 bighas, they have acquired 11 bighas, of which we have received the compensation money. But what we contend, my lord, that they have taken the entire plot of 25 bighas. And initially we raised.
no, then there has to be a direction to that effect that if they are only using 14 bighas to demarcate the land and give it back to them,
That was what was the direction given, my lord. That was.
that is not the direction given.
My lord,
Then adequate compensation as found appropriate should be released to the area without any further delay. Now the question is, how can there be a compensation without there being an acquisition?
Right.
One. Secondly, the same be conducted by the respondent number 6. Who is the respondent number 6?
my lord, the Secretary Revenue North Coast Hills Autonomous Council. Sri Tom Dawla.
Now who is appearing for him?
So RM Das was appearing. I would kindly page Lordship's order dated 27/4/26, madam. They had received the instructions.
And you say that he is not holding the post, APDCL.
Lordship. Although Lordship, we took the initiative to provide the instructions, Lordship.
Ah.
We have obtained the instructions, Lordship, and the joint verification was conducted, wherein we, APGCL, we participated, Lordship. And it was found out that the 14 bighas of land has not been acquired by the APGCL, Lordship. So the petitioners can use the land, Lordship. And respect to the.
Now, has that been, 14 bighas been identified?
Lordship, it was that has not been, that is our entire grievance. That has not been identified, and
Has it been identified or not?
Lordship, that we have only the letter that has been communicated to us by the.
No, my question is, unless it is not identified,
Lordship,
it is not.
because Lordship. only-
Anyways, we do one thing. We ask that secretary to appear in person, taking into account that council is not appearing. Huh? The council has not appeared, so we ask the appear, because without him, it is very difficult. So, Mr. So-and-so appears for respondent number 2, who submits that a joint verification was carried out, and it was found that the 14 bighas of land have remained unused, which the APDCL authorities would not require. However, for passing appropriate directions, the presence of the respondent number 1 is required. Full stop. No counsel on behalf of the respondent number 1 is present, for which the instant proceedings could not be brought to a logical conclusion. Considering the above, list this matter again on 15th of July 2026, on which date either the respondent number 1 shall be present in person at 10:30 a.m. to the video conferencing link to be provided by the Standing Council of the North Kachar Hills Autonomous Council, or the respondent number 1 be represented by a counsel. A copy of this order be provided to, who is the Standing Council?
RM Das.
Be provided to Mr. RM Das, the learned Standing Council of the North Kachar Hills Autonomous Council, for due compliance. Have you complied? Why?
compensation with some confusion regarding the exact amount. The matter was sent to the commissioner Rajai for the assessment, which is not seems to, but I want to play that section. But I'm sitting until 1 week then.
Sure. 1 week time. We'll have it on 25th.
Their calculation, admit was passed. And the calculation which was submitted page 15.
Anyway, she said that she doesn't have an instruction. We'll have it on 25th. Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 1 submits that she has not received the instructions. It is seen that such prayers have been made before this court since 10/11/2025. Under such circumstances, an opportunity, its final opportunity is granted to the respondent number 1 to place the instructions by way of an affidavit, failing which this court shall have no other option but to pass appropriate directions for initiation of the contempt proceedings. List the matter on 25/6/2026.
So we have filed the compliance affidavit yesterday.
Got the money? In pursuance to the order passed by this court, judgment and order passed by this court on 17/12/2025 in WPC number 3061/2025, the petitioner have duly complied by making due payment to the respondents. And in that regard, an affidavit of compliance have been filed by one Sri Biswajit Das, the chief editor of Ohomia Khobor, dated 19/6/2026. Mr. S. Day, who appears on behalf of the respondents, private respondents, also submits that the due amount have been received. Considering the above, nothing further remains for which the proceeding stands closed. What?
Great easy lordship. My lord, as per the previous order, I was supposed to obtain the correct address of respondent number 3 and to take steps, my lord. However, my lord, I did my research and the address is still showing the same, my lords. The matter pertains to freezing of the bank account.
Huh?
On account of suspicious transaction.
You don't know the address of the state of West Bengal?
My lord, the address is still showing the same. It's of political and home affairs. The address is still showing the same.
Then
My lord,
why you are not being able to serve it to the state of West Bengal? Why haven't you taken steps? 4/5/2026. However, the service is still awaiting in respect of 4 and 6. As regards respondent says that he liberty to obtain correct address. Rathi has sought for 1 further week's time to obtain the correct address of the respondent number 1. Respondent number 3. What is the matter about?
My lord, the matter pertains to freezing of the bank account on account of suspicious transaction.
Which bank?
SDFC Bank, my lord.
How much money?
My lord, 2 transaction, 26,100. And
Then
this,
why you are here? Why are you filing the petition here? Why you are not going to Tamil Nadu? Why? Why are you here? Everybody is there in Tamil Nadu, some in West Bengal. Why are you in
there is
Gauhati?
a complaint being
You
made,
don't reside here.
my lord, in
The
Azra,
bank is in bank branch who have done it is in Tamil Nadu.
Coimbatore. Yes, my
Coimbatore isn't it a part of Tamil Nadu?
my
Then why are you here?
because my lord, there is a complaint being filed in the Azra police station, Guwahati. Azra police.
You have
station.
not come for quashing of the FIR.
My lord.
Are you coming for quashing of
No,
the
my
FIR?
lord, no, no.
Then go there.
My lord, there was a complaint being made. If my
Go
lord,
there, go there.
my lord,
Absolutely no.
My
You are
lord,
not
there's a
being-
complaint in
No, you go there. Why are you filing it here unnecessarily? You see, the fact remains here. You don't reside here. One. Your bank account is in Tamil Nadu. There is something mentioned about the case of this in Assam. You can very well get the directions from there. Why are you here? The problem is this: you are not doing the good service to your client because he is not getting any relief. You are not being able to take steps. You see, this is a matter of 2025. A person's bank account being frozen from 2025 is not in good spirit. So better off go there.
My lord, the permit, I'll do dusty service in respondent. There's a complaint in Asra. If my lord, the permit, I'll do dusty service on respondent 3, my lord.
How does it matter? First of all, you are not here. Your bank account is not here. All others except one FIR somewhere has been filed for which it has happened. So then, go there. You get it. Otherwise, I would have passed this order immediately. But here the problem is, this HDFC Bank, you should have made the main person a party. Then we could have brought in Mr. M. Sharma and got it done. But here, this order has to be effective. We pass an order, then what will happen? And yes, madam, what is this?
That was
No
previous-
case in Azara. Then
My lord, that was previously placed. However, the acknowledgement number is different of Azra. This one is of some other state, my lord. I've already placed the Azra complaint, my lords.
where?
In the previous date, my lords, I also have another copy. I'll just place
No,
it.
no, you have not enclosed it. Where? All these withdrawn from trading accounts, so and so,
After
complaint
filing of
number
the writ
2,
petition, my lord,
complaint number 3.
this
Where is
complaint was
Azra?
provided.
Where is Azra? There is no Azra here.
I have not annexed that, my lord.
Then-
After filing of the writ petition, this
No,
Azra
no, no.
complaint we have received.
Dekho. Withdraw, dismiss. Which one? Dismiss. Heard Mr. Adi Rathi, the Lilith Council
My
appearing
lord,
on
I'll withdraw with, I'll close the
better.
other.
As on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent number 1 and 2. I mentioned that there is nothing. This will help you to go there and get an order because there is nothing out there because of this document.
Yeah, my lord.
Mr. Mathi, wait, let me pass down. The petitioner herein is a resident of the state of Tamil Nadu. The petitioner has a bank account in HDFC Bank of a branch at Coimbatore, Tamil Nadu. The present proceedings have been initiated on the ground that on the basis of a complaint being filed by in the Azara police station, Gauhati again. Azara police station. The petitioner's bank account have been frozen. It is also seen from the very petition itself that the petitioner's bank account has been frozen on account of various other cases filed at Malda, West Bengal, and Telangana. Telangana, how can there be a police station Telangana?
Coimbatore.
Telangana.
Telangana.
How can there be a police station? Do you have an Assam police station?
My lord,
Have you ever heard of?
represented by Commissioner Secretary of Home Affairs.
So what? How can there be a police station Telangana? Was that? Annexure 5, where is that Annexure 5? Telangana, where? How do you know Telangana? Police station?
My lord, the acknowledgement number, based on the acknowledgement number, we have approved the bank and bank has provided us the complaint after the filing of.
That
the-
is also not mentioned.
After the filing of the writ petition, my lord, we have received that, we have.
But
immediately
then
sought
how
the-
did you put police station Telangana?
My lord, I made the state as a party.
Again, another, here see, complaint 3, complaint reference number, so and so police station Telangana. Paragraph 10, page 10. What is this type of petition, Mr. Rat? And in the states of West Bengal, there are various other complaints in the state of West Bengal as well as in Telangana. Ms. So-and-so, who appears on behalf of the respondent, number 1 and 2 had submitted that the officer in charge of Azara police station had issued a communication dated 1/12/2023 stating inter alia that no complaint has been received and initiated by the Azara police station against HDFC savings bank account number 1250-114-000-5656, branch name Coimbatore, Tamil Nadu. And further, there is no and further the complaint number MHA 337102250051 was not initiated by the Azara police station or in the system of the Azara police station, any records are available. It is relevant to take note of the contents of the said communication issued by the officer in charge of Azara police station are reproduced here in under. The said communication is also kept on record and marked with the letter X. Taking into account the above, it is the opinion of this court that this court does not have the territorial jurisdiction under Article 2262 of the Constitution to entertain the instant writ petition. At this stage, Mr. D. Rathi, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to withdraw the instant writ petition and without prejudice to prefer appropriate proceedings in the High Court of, which one do you want? Tamil Nadu? Madras?
Kolkata. Yes, ma'am.
Why Kolkata? Nearby to you? Absolutely. Before the appropriate High Court. Considering the above, the instant writ petition stands closed on withdrawal. The withdrawal of the instant writ proceeding shall not preclude or prejudice the petitioner to approach the appropriate forum.
Much of it.
Yes.
But this is the case where we got some reassessment proceedings were initiated against me, my lord. And against that, my lord, I had approached the Joint Commissioner of Taxes, my lord, by way of appeal, my lord. And my lord, the Joint Commissioner of Taxes, my lord, allows my appeal. I'm sorry.
Who are the revenue officials who are tampering? This is some BM Gogoi.
Yes,
Yes, what is your case?
yes, ma'am. My senior, PN Gopal. I'm on behalf of my senior, PN Gopal.
Then what do you want?
Your lordship, my senior is in medical emergency.
Okay. At the request of the learned counsel appearing on behalf of this court have duly taken note of the Lozima Court's order dated 3/6/2026, wherein it is seen that the service upon the respondent number 6 has been completed. Considering the above, as the service is complete, leaves the matter for admission on 3rd of 2nd of September 2026.
Services has been done.
Why you are not taking steps?
We are taking steps.
Learned Council took steps on Iman in compliance with the
Yep.
High Court's order
Taken
in
steps.
issuance of notice upon responder but without ID card. On given intimation, AIA has furnished the ID card on 17th week, since the matter is fixed on so and so. Okay. Taking into account that, what is the matter about? Court has fixed it for maintainability, other courts, they don't dismiss. Let me dismiss it. Where is it? What is your case?
The case is that I was arrested in a land matter actually.
Ah.
While I was arrested, some police had taken a photograph of me and my wife while I was inside the jail actually. Then after a month's time, actually, one news web series had shown me my photo of myself and my wife while I was behind the bars in the jail.
Who has taken
Approve.
photograph?
The
For this photograph?
police only, but we don't know his name. So we have we had made the OC also here.
These annexure B and B1 are photographs taken by, this is in custody.
Custody means while we were thrown on the not in the jail actually, while we were in the lockup. So some photographs was taken by them, and after a month it was circulated.
Why you are not going before the civil court? What do you want? Compensation?
Yes.
Then
Yes,
go
sir.
to before the civil court, not here. Go for compensation. What has happened? Because there are two aspects. One is not only these people. They have not circulated. These police may have taken the photograph.
Then
The circulation is done by the other person.
other person.
So you have a case, maybe have a case against them for violating your right of privacy against them, or which may be a right on you that this photograph has been shown in bad light. Otherwise, the photograph is not in bad light. But if it is shown in a context that you are there for some reason, it's a case of defamation. So I think better off go to the defamation court.
Yes.
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 Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers 1, 2, 3, and 4. Good stop. The learned counsel appearing on behalf of the petitioner had duly submitted that on account of publications being made by the web news portal Times Gauhati of certain photographs which is alleged to be taken, which is taken by the respondent number 4. 4, no?
Yes.
4. Why do you say that? Don't say that. You withdraw. Don't come up with that statement because he has taken it or not. Don't do that. Submits that the petitioners have been defamed by the respondent number 5
Yes, sir.
in a program published in the web news portal of Times Gauhati. It is the opinion of this court that the instant dispute is primarily a dispute which is of civil nature. And under such circumstances, the writ court may not be, the writ court is not, and under such circumstances, the petitioner would be well advised to approach the appropriate civil court in this regard. Considering the learned counsel also appearing on behalf of the petitioner submits that the petitioner may be permitted to withdraw the instant petition without prejudice to avail remedies before the competent court of civil jurisdiction. Consequently, this court closes the instant writ petition on withdrawal. However, liberty is given to the petitioner to approach the competent court of civil jurisdiction, and the withdrawal of the instant petition shall not preclude or prejudice the petition. I'm like, you are. As Doctor, what is this? File the affidavit. Where it? Then accordingly. Where is the purging of the contempt? Purging. But immediately thereafter. You don't know the spelling of unanimously and anonymously? Page 66. It has a complete different connotation. Anonymously is something secretive. Unanimously is joined together. Accepted by so and so, they are that the extension of 1 beta would be cancelled and surplus amount will be refunded to him. But it's related to consent. Or the same day. This court have duly taken note of the affidavit which have been filed by the respondents. Respondent number? By the sole respondent. Wherein? The extension which was granted to the respondent number 6 in the writ petition have been cancelled. It is also submitted by Mr. S. Dutta appearing on behalf of the respondent that now fresh steps are being taken for the purpose of carrying out the settlement. You will be taking steps because there is a direction now. It's directed to undertake a process for fresh settlement of the market for the remaining period, or the remaining period is not there. He further submitted that the department would run the said market on its own, and if necessary, settle only by carrying out a fresh settlement in accordance with law. Taking into account the above, it is therefore the opinion of this court that the judgment and order passed by this court dated 17/2/2026 in WPC number 5076/2025 have been duly complied with. Accordingly, the contempt proceeding stands closed. Before parting with the record, this court, however, observes that after the order passed by the learned order passed by this court dated 17/2/2026 in WPC number 5076/2025, thereby setting aside the settlement made in favor of the respondent number 6 in the writ petition. The question of granting an extension to the respondent number 6 could not have been made. However, taking into account that could not have been made, inasmuch as extension of a settlement amounts to, inasmuch as upon setting aside the settlement made in favor of the respondent number 6, the settlement had become void, and as such, a void thing could not have been extended. But in future occasions, the respondent shall not repeat shall not take such steps in future.
May it please your lordship.
Yes.
Lordship, the IA is filed for praying for interim order of stay of eviction of the petitioner, lordship, because if the applicants have earlier filed a writ petition, the connected writ petition, seeking recognition of their rights over the land and protection from eviction. But on 11/6/2026, your lordship, the respondent number 3, along with the lot mandal and security personnel, went to the scheduled land and observed the said land and also made verbal remarks about clearing out the said land, your lordship. And pertaining to the similar evictions carried out in the nearby lands, the petitioner now apprehends that they may be evicted, your lordship.
Who? There is status quo granted
No, not in the connected writ petition, your lordship.
in other writ petitions.
In other lit petition, it is granted. We have annexed the 1563 of 2026, your lordship. Your lordship's order.
Yeah. Now, what do you want here?
Your lordship, since the writ petition is already pending.
The land involved in the petition has not been, What do you have to say?
I have gone through your lordship's order, lordship. Otherwise, he is entitled to, but lordship, today, most probably the interim order status quo can be given.
He didn't get a status quo earlier.
No, your lordship.
Here, at 12, page 16, paragraph 10. That's rule 18 is not applicable under the settlement.
Hmm?
And because this rule 18 is applicable
Oh.
in regard to the government land. This is
Ah,
regarding
this
the-
council has made a very,
Yes, sir.
last time, I still remember him.
Yes.
He has made a very beautiful argument on the thing. I've never gone across this particular line of, this type of,
Dominions.
land laws. I've never, in my life, have taken into account. Now, this is a very interesting argument which he has made out in his case. That the petitioner's grandfather was in occupation of land which was originally a part of so-and-so, and the petitioner's grandfather was a tenant of it. After the death of so-and-so, the petitioner's father and him. By the case of the petitioner that after coming into effect of the Assam so-and-so, the ownership of the land vests with the government of Assam, and by virtue of section 9, the petitioner's father became a right and was issued a final khatiyan on so-and-so. It is the case of the petitioner that by virtue of section 4(1) of the act, the status of the petitioner was that of a landholder. This act I have never gone through. Assam Land and Revenue Regulation 1886 in the Acquired Permanently Settled Estate Act 1970. Anyways, we pass the same order.
Okay. Status quo.
It is the opinion of this court that the power to evict in terms of so-and-so under is only limited to government, and as the settlement has been made in favor of the respondent number 5, 6, and 7, the state cannot exercise the powers of 18 of the settlement rules claimed under Iman in respect to the land wherein allotment or settlement has been made in favor of the respondent numbers 5, 6, and 7. Okay. Same case. Similar case.
Similar case. Only difference is the private respondent. Only difference is that in this one, the land has not been allotted yet to other persons.
Okay. Oh. Then?
The apprehension there
Then
being.
he is on presumption, lordship.
Huh?
Lordship.
Then he is on presumption, lordship.
You are in presumption.
Lordship, because on 11/6 recently.
Mr. So-and-so, the learned counsel appearing on behalf of the applicants who are the writ petitioners in WPC number 4263/2025. I've also heard Mr. H. Sharma, the learned counsel who appears on behalf of the respondent number 2, 3, and 4. And Ms. P.R. Mohanto, who appears on behalf of the respondent number 1. This court have duly perused the writ petition and actually the issue involved in the instant writ petition, in the accompanying writ petition, is similar to the issue raised in WPC number 1563 of 2026, save and accept. The land under the possession of the petitioners have not been allotted to any third party. Be that as it may, the petitioner have been able to make out the case as regards their rights, a prima facie case as regards the rights in terms with section 4.1 and 4.2 of the Assam Land Holding bracket adoption of relationship under the Assam Land and Revenue Regulation Command 1886 in the acquired permanently settled estate bracket close Act 1974. And as such, it is therefore the opinion of this court that the petitioner is entitled to certain interim directions. Accordingly, this court therefore directs that the interim order directs that the parties herein, parties to the instant to the accompanying writ petition, shall maintain status quo as on today over the land wherein. Where is the land? What is the area of the land? Land in dark numbers?
Page 6 of the IA, Your Lordship.
Huh?
Page 6 of the IA, page 5 and 6, Your Lordship, paragraph 2 of the IA civil.
And of old dark numbers 278, 244, 243, oblique 176, 267, 274, 397, 401, 804, 261, 801, 334, 3345, and new dark numbers 332, 331, 333, 345, 337, 338, 271, 364, and 379. Where's the land? Dark number of where? What?
May I point out one?
No, where is the land?
Situated in village Baniapada, Bilasipur Revenue Circle, Your Lord.
Situated at
Lordship.
village.
Lordship, Lordship, a second. Actually, it's describing the original writ petition, Your Lordship. I'm just. Lordship, page 15 of the writ petition, connected writ petition. Of Musa Anandanagar under Bilasipura Circle, Lordship.
No, you have not mentioned about those darks. We mentioned only about these darks which are mentioned at paragraph number 6.
Lordship, those are old ducks and new ducks together, Your Lordship. Whereas in the original writ
Petition number 36, we only mention about this one. Shall maintain status quo as regards the land at measuring 51 bighas, 1 katha, 9 lechas covered by old Khatian number 36, dark number 278, 244, 243, 176, 267, 274, 397, 401, 404, 261, and 402 of village.
village Anandanagar, Your Lordship.
Where do I get
It's
it?
not there, Lordship.
Huh?
Lordships may kindly come to page number 15 of the writ petition. There the schedule is mentioned.
In the schedule, only the DAG numbers have mentioned, but in the new IA, Your Lordship, the new
No,
DAG numbers have
You
already.
cannot,
Of the
this land
shall
measuring
maintain
51.
status quo in respect to the land as described in the schedule to the writ petition being WPC number 4263 of 2025. I stand disposed. Shall maintain status quo till the next date fixed in the accompanying writ petition. In respect to the land described in the schedule to the WPC number 4263/2025. I stands this to main column. Mr. So-and-so, the learned counsel appearing on behalf of the respondent numbers 2, 3, and 4 submits that they would like to file an affidavit in the instant proceedings. Accordingly, list this matter on 27th of July 2026. In the meantime, the state respondents shall bring on record their stand by filing the affidavit on or before 22nd of July 2026. The interim order passed in the ISC number 2042/2026 shall stand extended till the next date.
Much obliged, Your Honor.
Please get back to the eyes for having no understanding.
What is this?
This IA has filed for vacation of stay, madam.
You have filed for vacating.
Yes, ma'am.
What is the matter about?
But the case of the writ petitioner is that, my lord, they sought, my lord, that the compensation which is to be given by the oil.
Where is the order?
My lord, the order is at page 94, my lord. My lord, the actual order is passed in WPC 420, my lord, that is at 94. Operating part, my lord.
Transfers on the materials in the parcels of land of so and so belonging to the petitioner have been acquired by the respondent number 1 and the compensation amount have been accessible. In view of the above by the petitioner, it is ordered as an interim measure that if any part of the assessed compensation amount has remained to be disbursed, then the same shall not be disbursed till the returning.
That is passed in WPC 420/25. And my lord, this order operates in the instant case also, my lord, page 102, my lord.
Huh?
Page 102, ma'am. The order passed in the instant case. 102, last.
Okay, so here this is disconnected. Now, who are you?
I am the, my lord, presently running, there is a tea estate, my lord. Tea estate, my lord, in question, my lord. I am running the tea estate. And my lord, as well as I am the proposed purchaser of the tea estate, my lord. So, my lord, what happened, my lord? Oil India has acquired some portion of the land of the tea estate, my lord. They paid the surface compensation and all to this, the applicant, my lord. Thereafter, what happened, my lord? There altogether, there are 38 landowners of the tea estate, my lord. One of the landowners had filed a writ petition by saying that, my lord, the oil in collusion with this applicant has given the compensation without him being any authority, my lord. And they have filed.
What compensation?
Well, there is a
Compensation under what provision?
compensation of the consideration for the land, man. The consideration.
I think I understand. No. It's a civil dispute. Why should we entertain? Either it's a civil dispute. No, Mr. Both of you. It's a civil dispute. Either if it is an acquisition, then you have a court.
Not acquisition.
Not an acquisition, then you have to go to the civil court. Why should we entertain? Payment will be made by Oil India to somebody. How can you obtain an injunction before this court? Huh? Understood. No, how can we decide? This court is not a, yeah. No.
He's not the co-owner. He's the director of this tea standard. We are the co-owner.
I am not saying that he should get it. But the fact that how is your reputation maintainable here?
Lordship, therefore, Lordship, I am asking one day time because this case is lead by senior to the medium authority have technically come to the week and Lordship. But we one day accommodation, Lordship, he is not satisfied, Lordship, this was referred.
Well, we dismiss it or when do you want the dismissal?
Any day, Lordship. Lordship,
Tomorrow?
Lordship. Or you will come to the Monday only. Monday.
Okay, Tuesday we dismiss.
Tuesday, Lordship.
Leave this matter on Tuesday. Why? Who are you? Petitioner? Are you a petitioner? Then when I'm dismissing your petition, what is your business? Yes.
Well, this matter relates to non-payment of the hire charge of the vehicle. The
Hire
last
charge?
order that is
You got your instruction? Higher charge by civil cost. Who has to pay? Thai Development Council. Who has taken?
that was hired by the Ahom council. Yeah.
Home Council, why you are making the WPT as well as the finance a party?
Because they have made the communication to the debt authority for making the payment, release the payment. I have the annexed the document also.
Show me that. Why the amount is to be paid?
Yes, madam.
Bill for higher charge of year to so and so.
Lordship, kindly we look at the page, my lord, the next 3 at page 19, my lord.
50,000.
Page 19, next 3.
3,023 lakhs. And we can. You put this on affidavit. Director of? Okay. You are otherwise Directorate of Tribal Affairs claim.
My lord, the actual facts is this. Initially, the WPT was the authority, but subsequently, that has been bifurcated. So now the
No,
yes, madam.
not bifurcated, trifurcated. You have this tribal affairs thing, then you have Boroland one thing, and he is the main person. He is the main person for WP.
But that is
Now, how many? Tripartite, which are they? Four?
Modular.
So there are three. So we do one thing. We substitute the petitioner number, respondent number 1 by the directorate of, it's a directorate or what is that? It's a department. Social Justice and Empowerment. So we make, instead of that, we convert it to Social Justice and Empowerment Department. That will help. I think you have to make that a part. But why should we make? Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Finance, no finance. Tayahum, anybody appearing for Tayahum?
Copy was served, they have received, but none is appearing.
Technically. It has been informed to this court that by a government decision, the WPT and BC department of the government of Assam have been bifurcated into three departments. First is the Department of Social Justice and Empowerment. Second, the Department of Tribal Affairs. And third, the Department of Boroland Welfare. Insofar as the Directorate of Scheduled Caste and Backward Classes is concerned, who looks after the affairs of the respondent number 3, it comes under the Social Justice and Empowerment Department. Under such circumstances, this court substitutes the respondent number 1 by the state of Assam, represented by the Commissioner and Secretary to the Government of Assam, Social Empowerment and Justice Department, Dispur, Gauhati 781006. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties. Now, in addition to that, this court also includes the commissioner, the director of tribal affairs, claim.
Civil council back up.
No. Director, we can make director tribal affairs plain, then no, or we make the Directorate of Scheduled Caste and Backward Classes represented by the director plain. He has written this letter. Okay, who should it be? That's it. Okay. Director. In addition to that, this court also includes the director of the Directorate of Scheduled Caste and Backward Classes. Having its office at Promotional, Dispur, Gauhati 781006 as the respondent number 4. Mr. Bellane counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the said memo of parties and the order passed hearing, shall make necessary correction in the cause title as well as update the same in the CI 7 days day. Ms. P. Chakraborty accepts on behalf of the substituted respondent number 1 as well as for the respondent number 4, extra copies of the writ petition be served upon her by tomorrow, by Monday. List this matter again on 10th of August 2026, on which date an update shall be provided as to the entitlement of the petitioner. 1 and 4.
Chief Secretary.
They made another one, Chief Secretary.
Chief Secretary, by your lordship order.
What? Okay, 5 point. Mr. Mohanta, you have taken a lot of generosity from the spot of filing one after another.
The compel me, my lord.
Huh?
Compel me, my lord.
Well, there's no compelling anything up. Okay,
Because
one
I
is-
am not getting the action where to I have to go, my lord. It's a different.
now I think it is
Yes, my lord. Now it's constrained, my lord. Must.
1 and 5 point. Debo Prashad Brahmo, SS Tanupura. Well, what is this? What do you want?
It's a compensation issue, your lordship.
Huh?
It's regarding ROW, a right of way, your lordship.
Where?
In
Right
Kokrajhar,
of way, we have never heard.
Kokrajhar
I
Revenue.
normally get this right of way business out there in Kohima. What is this right of way in Assam? Huh? BCC. BCC. Right of way.
Power grid, your.
Power grid, who is appearing? Okay, he's asking for certain amount.
Your Honor, no compensation has been paid till date.
Ah,
Lines have been erected in 1986. Since 86, no compensation has ever been paid. In 2022, reconducting process was undertaken. However, they have only now in their objection, they have agreed that they will be paying Jirat. But we are looking for more beyond Jirat, Your Honor.
what do you want?
Your Honor,
What do you want?
2015 guidelines, Your Honor.
Then 2015, then
2000
that
now
you-
2024
No,
guidelines have
no,
also.
this is power grid. Why are you not going under section 16 before under the Indian?
Your Honor,
paragraph?
before 16, 10D has to be 10D has to take place, and then 10D
What?
10 Your Honor 10D
Sale deed?
10 section 10.
Huh.
Uh,
They have
that-
not initiated.
No,
section
Your Honor.
10. You
They
not,
have they have
you have
mentioned
not
that
taken initiated section 10.
no assessment has been done, Your Honor.
It has to be taken by the department.
Paragraph 6, page 125.
Hmm?
Paragraph 6, page 125.
Six.
Paragraph 10. That's the first section.
The statement may be the transmission line in question is erected in one since the fossil line is moving the state and circulating the customer.
That's right.
While things of demand. Persons necessary compensation is to be paid after making supply. Now, is it over their land?
Yes.
Yes, Your Honor.
Yes.
Have you paid any compensation at that point of time on the land?
Yes.
You must be having orders of that awards.
I have not. But Lordship,
No, Mr. Counsel, that is not done. You have
it was a
to,
matter of.
there has to be something by which you take over the land.
Yes, Lordship.
How?
Lordship, it is a matter of 35 years old.
So what?
Lordship, but Lordship, they are saying that new construction has been taken. It's really wrong.
Chalo. Okay, we'll have it after vacation some other day. But if we, next time it comes out that, I think you make the BTC a party, Mr. Counsel. It is the opinion of this court that for a proper adjudication of the case, the revenue secretary of the BTC should be arrayed as a party to the instant proceedings. The counsel appearing on behalf of the petitioner submits that in that regard, appropriate application would be filed. So list this matter on such application filed.
Obligation.
Yes, what is this, Mr. Das?
Forest quality. But there was certain observation that was made by this court saying that there has to be a mechanism to be followed by the authority. Please see
that while evolving the mechanism, some
At paragraph
modalities to evolve whereby forest department. Yes, what has
Forest-
happened? Anything?
they can't do that. That's my lord. Before preceding paragraph, kindly see my. Yes. It is a mechanism to proceed. Yes.
Somehow, you have to do something.
These cases were never matter. Correct. I say yes. They purchase some kind of mixtures. Some from ready-made concrete. If that plant which produced that mixture, ready-made concrete, that source is well depend on not that we are finding it very.
So therefore, how can you impose upon him? You see, the payment of royalty is upon whom? No, they are doing it on your instruction. They have, you see, normally the payment of royalty will be under Rule 5. Next comes, provide Rule 5 only comes into picture when the contractor has been given an area for mining. 5B. Or under 8, mining lease. Or under 28, contract. Here is a case where he has purchased certain amounts, certain mixtures from somebody who makes that mixture.
Yes.
And he must have purchased these minor minerals of wheat, sand, or air from another person because he also doesn't. And he is selling this mixture or using that mixtures in the as a bitumen in his roads, and he is deducting. So unless you can evolve some mechanism, how can you deduct? My question is, that is why I said yes, there is a necessity. How you can trace it out? I never asked. I therefore asked the last time. You see, you may not have read the order properly. And the problem arises, you keep on changing the councils. That day R.R. Gogoi appears, today you have appeared, and tomorrow Mr. Ibotako will appear. And then again you are going to appear. And thereby all are there is the
Because the view of this court,
what have action have you taken in pursuance to this order? Where is the instruction to the effect? Telephonically. You also explained to them by phone this order.
No, yes, send it. And then send it.
When did you send it?
Once we have communicated.
When?
Formally, but informally, which I will, and you have therefore have asked to.
No, not Jorhat. It is nothing to do with Jorhat. You have to have an overall system, mechanism. Now, if you don't have a mechanism, you are going to lose. I can very well pass an order out here that he is not entitled to, the matter ends there. But the problem will be of the forest in losing of this revenue. So how do you trace out? When we give an opportunity to the forest to come up with a solution, they don't, then obviously they will going to lose the revenue. My only question is thinking about the forest I did it. Otherwise, the case is covered by my judgment of
Yes.
Muslim Ali.
yes,
There's no quarrel with that. So therefore, issue is not that. So therefore, I came up with how, what modalities can be done. And again, you are, and this you are going to make it, then tomorrow, Botago will come.
No, yes, I'll.
No,
In the same team, minus.
no, there is no same thing. All that is the biggest problem with your forest and the PH. Huge big problem. Today he says this, tomorrow he says, oh, I didn't know. And excites. Big problem. You're working, you should have worked out that. Otherwise, for me to pass that order is very simple. Here I have categorically mentioned. I'm going to give the attention of this court to paragraph 8 of the affidavit in opposition filed, wherein it is stated that the NRL is bound to deduct the forest royalty in view of 5383 of the Iman. It also mentioned that when a contractor is unable to prove the payment of the requisite forest royalty by submitting the appropriate soils are required to withhold. R.R. Gogoi so and so fairly submits that forestry is a one-time imposition. It's a one-time imposition. So if for that it has been paid, it cannot happen. So you have to put something at that end when it is extractive. We cannot do this. Something has to involve some mechanism. I therefore ask you for this litigation. I kept you so that you can uniform it somehow. How you can do it? Think about it. Anyway, we'll have it after vacation. You in the meantime think about this thing. Wonder how it can be saved also, and difficulty is not there for the authorities, for the people also. If they are to pay, they should pay. But how can they pay? Because here, this is the third person. One person purchases the sand and brick, sand and chips. The second person, he sells it to one person. He makes a mix. This mix he purchases it and uses to him. So this is the fourth. He gets the fourth. and he deducts from him.
Yes,
Isn't it?
yes, that's the case. We are trying to keep it up with technology, because when the rules were there, it was well the rules. This pictures is propped up with.
Mitcha was not there.
Yeah, picture of batching pictures was there. These kind of automatic pictures of. It was there. It was there, but this kind of is there.
Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that though instructions have been sought for by the pursuant to the order passed by this court from dated 6/5/2026, but the six instructions are awaited from the PCCF. This court would like to observe that by the order dated 6/5/2026, this court granted an opportunity to the Forest Department and more particularly to the PCCF to work out a modality so that unnecessary litigation on account of deduction of forest royalty by the corporations as well as the government in respect to materials which have already suffered forest royalty do not arise. This court fixes this matter on 28th of July 2026. It is the opinion of this court that this court observes that if the Forest Department, and more particularly the PCCF, is not willing or not coming forward to arrive to place a modality by which these aspects can be resolved, this court shall pass appropriate directions on this next stage. Pursuant to the order passed by this court, on 17/6/2026, Mr. B. Gogoi, the learned additional advocate general, have placed before this court the up-to-date calculation till 18/6/2016. The amount payable to the petitioner. The said calculation is kept on record and marked with the letter X. From the said amount, it is from the said calculation, it is seen that the petitioners, as on 18/6/2026, is entitled to an amount of rupees 13,70,000, 78,000 and 30. Mr. R.C. Saikia, the learned senior counsel. Have also placed before this court as directed in the order dated 17/6/2026. A power of attorney executed by what about one person is not there?
Mangini Manka has died, man. I have placed the death certificate.
A power of attorney executed by the petitioner number 2, 4, and 5, thereby empowering the petitioner number 3 to receive the compensation in reference case number 160 of 1992. As per the directions passed by the reference court in the judgment in reference case number 160 of 1992 dated 7/12/2001, and the judgment and order passed by this court in WPC number 5522 of 2015 dated 21/9/2017. In addition to that, the learned counsel have also placed before this court the bank account along with the bank account details of the petitioner number 3, wherein the amount is required to be transferred, and the next of the kin certificate. The death certificate of the wife of late Prabhat Chandra Mohanto have also been placed. The death certificate of the petitioner number 1, who is the wife of late Prabhat Kumar Mohanto, have also been placed. Considering the above, it is the opinion of this court that these documents would suffice. The said documents have been handed over to Mr. P. Gogoi, the learned additional advocate general, who is also the standing counsel of the PWD department. To take effective steps for release of the amount of rupees 13,78,030 to the petitioners. The said amount be released on or before the next date, and an update be placed before this court to list this matter on 15th of July 2026 at the top of the list for an update. Yes, Mr. Setia. Inform me, these copies you give it to us.
Yes, it is here, yeah. First thing is that, you send me. I'm handing over it, my lord, to my friend.
Inform the, make the payment, else pays consequences.
And that we are obliged, because after long lapse, we will achieve has given the final limit.
We will see when you will get the money. I hope you get the money.
Case was lingering for a lot of time.
It won't, therefore
Only on your lordship interference.
I've shown it as part heard. So the
Yes,
matter
my
will
lord.
go.
We are very much obliged, lordship.
Yes, your Erica nuts. I
My
put a specific question
My
to
lord.
you. How on earth?
My lord, as per your lordship direction, my lord, additional affidavit has been filed, my lord. Lord, will take the additional affidavit, my lord. As at page 5, Roman 4, my lord. That the betel nut were purchased from Hailakandi, Assam, which is evident from the generated tax invoice dated so as annexure at page 69 of the writ petition. That the betel nut was loaded in the truck from Hailakandi to bring it to Rupai. Rupai at Godown, Nagaon, which is 352 kilometer distance in between two places. That the betel nut was with truck was intercepted in between the en route at Karimganj area by the Badub customs authorities while it was coming to Rupai at Nagaon, my lord. My lord, kindly come at page Roman 8, that the betel nuts are Indian origin and the customs authorities have illegally unlawfully seized on the figment of imagination to the effect that the above goods have been smuggled from foreign country. My lord, region, my lord, I have placed several it is my satisfaction, my lord.
Mr. Counsel,
My lord, it goes.
Mr. Counsel, Mr. Kyle, tell me, have you carried out any testing to find out that it is outside, it is not profit? Well, put the mic in your face. Mic towards you. Yes.
I have given the copy of the notice.
Have you tested it out?
Yes, we.
Test report
Test report says that
fit for human consumption.
No.
regarding
That-
lordship,
No, you have to have something. If
quarantine
you
report-
don't find anything, either you are supposed to catch it out there while transporting from Burma or wherever it is,
Right.
one. Or if you have some materials to show that it is of foreign origin, your mere suspicion would not do.
Lordship,
Yeah.
lordship, pleased to see the notice. I have
The notice is okay. I'm not
after
on
completion of the
notice
investigation, lordship,
My lord, I am covered by Supreme Court judgments as well as judgment of division bench. My lord.
Yes, my question is,
lordship,
it is believed to be of foreign origin.
lordship.
His belief of being of foreign origin happened sometime in the year 2025.
Lordship.
We are in the middle of 2026. Have that belief converted anywhere nearby to the actuality, or it is still a belief? Then you have to release it.
Lordship, pleased to see the notice.
I'm not going to see the notice on all these things. First of all, you cannot keep it like this unless you carry out your activities for the fact that whether these are of you had so many 6 months almost. You have not carried out any test.
Lordship, test is carried out, report is there. The report from
Where is the test?
Lordship, with respect to foreign origin, the report is silent.
Huh?
Report is silent with regard to whether it is a foreign made or Indian.
Then matter over.
Lordship,
Then you have no business. Customs have no business, whatever it may be. There is nothing out there. There is known to me as a local transporter and so and so. There is nothing out there. Well, now you cannot do all these things. It is high.
notice under section 124, there is a finding to that effect.
What is the one?
124, on the top of the my lordship file.
Copy of the notice. Notice was issued when?
On 5/6/2026.
5/6/2026.
26. Not
What do you say?
the proceeding
All
before
evidence on the Airbnb may be submitted with a reply during the stipulated period as pending which will take to be defined in the document. This is the so-called notice you have issued.
yes, lordship, under section
Thorough
124.
of the trial was carried out and in presence of the witnesses and during the process it was observed that the truck was loaded with electronics of foreign origin. How are you saying foreign origin?
Because lordship,
Unless you could not find out.
lordship, because there
It
was
was
a
believed. Have you forgotten the word believe? Assumption. You can't do that. Suspected. Now this suspicion happened on 1/12. You should have carried out the test. And where is the test? There's a test report. We have to,
Quarantine
all
report
these
is not
things have to be, these are absolute. The case of absolute perversity of justice. Have they said anywhere?
Not it.
Have they said anywhere to that effect that these particular the Areca nuts are belongs to
Because
these are, I got it from Myanmar.
they fail to satisfy the authority that it is Indian origin law. That finding is there.
How can there be anything more? That is your show cause. That can't be a finding.
No, Lordship, that is because notice has been issued after.
No, unless you have the mechanism to find out as to whether it is or foreign origin or not. Are you saying that in an area like Hailakandi, there is no the betel nut cultivation?
But it is there, but Lordship, the size and the price, Lordship is page 56,
Ah.
66. While they're considering their application for provisional release, Lordship, the authority come to a finding, page 66, paragraph G
Of which one? Yeah,
of a writ petition,
page 66.
paragraph G.
G.
Very good.
As stated above, it is
Registered.
apparent that an attempt to smuggle the goods into India have been done in violation of the exit policy and requirement of the provisions of the Custom Act. As per so and so, import of Areca below so and so per kilogram is prohibited. Had the consignment been legally imported, the covering invoice would have been indicated a price that would have been more than so and so kilogram. This is a case of smuggling in violation of the Customs Act and so and so, hence here. But how do you say so?
It is an allegation, my lord.
No. My question is, how do you say so unless you have any proof to that effect that it is so of foreign origin, or you are in a position to distinguish? Now you have sent it for testing somewhere. These people who have tested, they did not find anything. Then,
My lord, Supreme Court says reasonable belief or reason to believe must be backed by objective, tangible evidence. And Supreme Court further says, belief cannot be born out of thin air, gossip, or raw suspicion. Supreme Court.
I also believe.
My lord, my lord. In. Well, kindly see. Well, Supreme Court 1976. SCC, my lord, 757, my lord. Then, my lord, it is brought in recent judgment, my lord. 2025 Supreme Court judgment, my lord. It has been brought. Next, my lord, Division Bench of Allahabad High Court, my lord. Right on the point, my lord. Well, kindly see.
Which paragraph of the Allahabad High Court?
My lord, Allahabad High Court, my lord, kindly come at page, running page, my lord, 46 and 47. 45 and 46. Running page. 45, my lord, paragraph 30. On the contrary, the present case as demonstrated by the petitioner is that the goods in question were purchased in an e-auction held by the customs authorities themselves within the territory of India. The fact that there was evidence in the form of transport documents to show that the goods were being transported within the private reason to believe recorded are unsustainable. It is well settled that the reason to believe must be based upon acceptable materials which have to be more than a moonshine. The material on record overwhelmingly suggests that the reasons to believe were based upon the opinion of the local dealers, prima facie examination, so and so, so and so. My lord, next page, my lord. Paragraph 34. Thus, the basis of formation of reason to believe as recorded in point
Mr. Counsel.
only illegal.
Mr. Counsel, take your seat.
And
Take your seat.
my lord, only about satisfaction. I was showing Supreme Court judgment.
Mr. Counsel, I don't require Supreme Court.
Fine.
Take your seat. We pass the order. Really.
Lordship.
Heard Mr. So and so.
Finding of the authority, Lordship. It's on to you, Lordship. This is the finding of the authority while rejecting the application for release on the provisional.
Where? No, I'm not on that. That release on a, first of all, unless you have materials to come to an opinion, yes, I would have understood on that day you could have done it on the hunch because it was nearby. Very well. You can go and say, we believe it to that. That belief is okay at that point of time. You had the opportunity. And after the opportunity also, you have not been able to show to or find out or anything to that effect that these areca nuts actually belongs to Burma, Bangladesh, wherever it is. Unless you have arrived at some substantive material, your entire reasons to believe cannot be substantiated. Take your seat.
Well, just one,
No.
my satisfaction. I beg your lordship pardon, Madam. But Supreme Court says,
Mr. Counsel, if you argue any further, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.C. Kyle, the learned senior counsel assisted by so-and-so, appears on behalf of the respondent numbers 1 to 5. The petitioner herein, which is a proprietorship firm belonging to one Horum Rashid, is in the business of Bill's nut, oblique areca nut. The petitioner herein, which is a proprietorship firm of one Harun Rashid, has filed the instant with petition challenging the seizure of the areca nuts by the respondent number. Yes, now you say by respondent number, who has done the seizure?
my lord, supervisor 4, 5, my lord.
By the respondent numbers 4 and 5. The brief facts of the present case, as would appear from the materials on record, are that the petitioner purchased 17,500 kilos of Assam dried areca nuts Now, you did not purchase it, you sold it to Harun Rashid.
Another, both are Harun. Both are Harun. Both Harun are different person.
No, the petitioner sold it. Kindly see annexure A. From Alia to Harun Rashid. Isn't it?
Well,
So Alia is selling it to Harun Rashid.
Alia provider of Harun Rashid and the separate person Harun Rashid. I have annexed both the Aadhaar card and PAN card, my lord, on the basis of your lordship's direction. Additional affidavit.
The petitioner procured collected from different sources 17,500 kilograms of Assam dried areca nuts. And sold it to one Harun Rashid. At this stage, it is very pertinent to take note of that the proprietor of the petitioner is also one Harun Rashid. Who is the son of Abdul Ghaffar, and whose Aadhaar card number is 626157179012, and his PAN card number is ALHPR 0006M. The person to whom the petitioner firm sold the said 17,500 kilograms of areca nuts was also one Harun Rashid, who is the son of Hazrat Ali, whose Aadhaar card number is 216683622760, and his PAN number is AYAPR 9589F. By the transaction carried out on Thirty 11/2025, these areca nuts, these 17,500 kilograms of areca nuts, having the total invoice value of rupees 3 crores 38 lakhs, no, 33 lakhs 81,000, was sold to Sri Harun Rashid. The said areca nuts were required to be transported by truck from Hailakandi to Rupohihat Godown at Nagaon, which is around 352 kilometers. The said truck was intercepted at Karimganj area by the Badarpur customs authorities while it was coming to authorities. Full stop. Where is the Caesar memo?
Page 25, looks, and it's a B.
25.
Yes, Lord, there is a discrepancy in the weight.
Okay.
Column 1. 215 bags, net weight 17.
The said Areca nuts thereupon was seized by the respondent number 5.
What's the respondent? He has not been made party.
Okay.
Respondent number
By seized by the Inspector Customs Prevention Force, Badarpur, on 2/12/2025. The reasons for the seizure, so mentioned in the seizure memo, in the inventory of the goods seized, was an attempt of smuggling oblique illegal import into India through a route other than the route specified under Section 7(1)(c) of the Customs Act 1962 without having licit documents in support of its legal possession, oblique transportation, oblique importation, and in violation to Section 11, ibid red with export bracket control order number 1/88 dated 30/3/1988 as made applicable to Section 3 and 4 of the Foreign Trade Development and Regulation bracket close Act 1992. The records further reveal that the petitioner thereupon, on coming to learn requested for provisional release of the said Areca nuts. On 7/1/2026. On 13/2/2026, the petitioner was informed that the petitioner's application for provisional release was disallowed by an order dated 12/2/2026. The provisional, the order dated 12/2/2026 is relevant inasmuch as the said order recites the reason as to why the seizure was made. It was mentioned at paragraph 2F 2E and F. Paragraphs 2E and F. Subparagraphs 2E and F of paragraph 2. That it was reasonably believed that the areca nuts were of foreign origin, which were suspected to have been illegally imported into India from Myanmar. Subparagraph I of paragraph 2 is also of much relevance for the purpose of the present adjudication, inasmuch as it is mentioned that samples were drawn from the seized goods from all the bags. As mentioned in the schedule to the inventory. It was further mentioned that 2 representative samples, each weighing 500 grams, were carefully drawn randomly from the consignment, securely packed, sealed, and marked as sample S-01 and S-02. These samples were taken to ensure that they accurately represent the entire quantity of the seized material. The purpose behind taking of the sample is also mentioned, is to facilitate their subsequent laboratory examination and testing in order to determine the nature and origin of the goods and to assess whether they are fit for human consumption in accordance with the applicable quality and safety standards. It was further mentioned in the said order that the laboratory examination report, which was submitted by the State Public Health Laboratory, Bamuni Assam, found that the samples conform to prescribed standards as per the food safety and standard regulation with respect to the test carried out. It was also found that the goods are meant for human consumption. It was also mentioned that on examination of the packagage, no FSSI license number was printed on the package as required under the FSSI Act 2006. However, it is also very relevant to take note of that though these samples were drawn for the purpose of testing, and relevant to take note of, that the samples were drawn for the purpose of testing for 2 reasons. One, as to whether it was fit for human consumption, and the second, as to whether the areca nuts in question were of foreign origin. In spite of the testing being carried out, nothing could be shown that the areca nuts in question were of foreign origin. And this aspect would be apparent from the order dated 12/2/2026. Be it as it may, the applications so filed for provisional release of the areca nuts were rejected. It is under such circumstances, the petitioner being aggrieved has approached this court by filing the present writ petition. The learned coordinate bench of this court by an order dated 25/5/2026 issued notice making it returnable by 2 weeks. It is also taken note of that in pursuance to the direction passed by this court, the liberty so granted by this court by the order dated 4/5/2026, the petitioner had filed an additional affidavit detailing out the manner in which the areca nuts in question were seized. This court have heard the learned counsels appearing on behalf of the petitioner, as well as the learned counsel, learned senior counsel who appears on behalf of the respondents. This court have also perused the materials on record, the records which have been produced by Mr. S. C. Kyle, the learned senior counsel appearing on behalf of the reasons. Appearing on behalf of the respondents. The question which arises for the determination in the instant proceeding. Where's the power to seize?
One 110 law for custom bit.
As to whether the question which arises in the instant proceedings is as to whether the exercise of the power by the concerned respondent authorities to seize the areca nuts in question was in accordance with Section 110 of the Customs Act 1962, or short, the Act of 1962. A perusal of section 100, subsection 1 of section 110 of the Act of 1962 stipulates that if the proper officer has reasons to believe that any goods are liable to confiscation under this Act, under the Act of 1962, he may seize such goods. Where is the provision for confiscation?
So we have to issue notice.
No. Where is the provision? Which are the goods liable to be confiscated?
Not so.
It will be given somewhere, no?
It is there. Hundred and 11.
Section 111 of the Act of 1962 stipulates the goods which are liable to be confiscated. A perusal of the said provision would show that the power to confiscate is solely in respect to goods brought from a place outside India. Goods. Section 115 also empowers confiscation when goods were attempted to be improperly exported. Be that as it may, a conjoint reading of section 110 bracket 1 of the Act of bracket 1 and section 111 of the Act of 1962 would show that only in respect to goods which are brought from a place outside India, the same is liable for confiscation. And it is only when there is a reasons to believe that the goods in question are liable for confiscation in terms with section 111 or for that matter 113 of the Act of 1962, the power can be exercised. This court finds it very pertinent to take note of. the expression reasons to believe which is employed in section 110 of the Act of 1962. The Supreme Court, in the case of income tax officer, comma, 1 ward, comma, district Roman 6, Calcutta, and others reported in Lakshmani Mewal Das, reported in 1976 versus so-and-so Lakshmani Mewal Das, reported in 1976, 3 SCC 757. Categorically observed that the reasons for formation of the belief must have a rational connection with or relevant bearing to the formation of the belief. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the officer and the formation of his belief that there has been escapement of income. The Supreme Court categorically observed that there is a huge difference between the terminology of reasons to believe with reason to suspect. In the backdrop of the above, if this court duly takes note of the grounds of seizure as mentioned in the inventory of the goods seized, there is nothing mentioned in the said document as to why there was a reasons to believe that the goods in question, the American nuts in question, were believed to be of foreign origin. It was only mentioned that there was an attempt of smuggling of illegal import into India through a route other than the route specified under Section 7(1)(c) of the Customs Act 1962, without having licit documents in support of its legal possession, transportation, importation, which was in violation with some of the provisions of law. It is the opinion of this court. This court have also perused the materials which is the tax invoice, and the payment of the GST. Including the What is that bill? E-way bill? E-way. E-way bill. Which clearly shows that the documents in question were there to show that there was a sale between the petitioner as well as Sri Harun Rashid. And it is in pursuance to the sale, the goods were moving from Hailakandi to Nagaon. Rupohihat, Nagaon. The provisional, the rejection of the provisional release, the rejection of the provisional provisional release order dated 12/2/2026, however, provides reasons to the effect that it was suspected that the areca nuts in question were of foreign origin. This court also takes note of that samples were drawn, as would be apparent from a perusal of the order dated 12/2/2026, to verify as to whether the areca nuts in question were fit for human consumption, and also as to whether to test the nature and origin of the goods. Though the laboratory reports categorically mention the same to be the goods to be fit for human consumption, but there is nothing on record to show, records which have been produced to show that there are reports to show that there are reports that the areca nuts in question which were seized were of foreign origin. It surprises this court to take note of that the custom authorities were more bothered on the petitioner not having an FSSI license, which authority solely lies upon the the jurisdiction of which lies upon the authorities under the FSSI Act. Under such circumstances, as there is nothing on record to show that the goods in question were of foreign origin, the question of the said goods being brought from outside India does not arise. If the goods in question are not brought from outside India, there cannot be an applicability to Section 111 of the Act of 1962. And if Section 111 of the Act of 1962 cannot be brought into service. The seizure so carried out under Section 110 of the Act of 1962 would not be permissible. It is also the opinion of this court that the reason that as there are no materials to show that the goods in question were of foreign origin, the reason to believe, the basis on which the seizure was carried out cannot be said to be a reason to believe, but rather it was a reason to suspect. And therefore, it was without jurisdiction, as the condition precedent of having the reason to believe was not there. Accordingly, the seizure, the instant writ petition, therefore stands disposed of with the following observations and directions. The seizure of the areca nuts in question made under in terms with the inventory of goods seized by the Inspector Custom Preventive Forces Badarpur on 2/12/2025 is without jurisdiction and authority of law, for which the same is set aside and quashed. Number two, the respondent herein, more particularly, whom? Inspector?
Inspector of,
Inspect the respondents herein, and more particularly the inspectors,
what's the response?
Customs Preventive Force, huh?
He has not been made party here.
Not necessary.
No, my lord, kindly say custom authorities. My lord. Customs authorities.
This one, it is the
Additional-
lying in the Badarpur law.
Well,
Huh?
well,
It is lying in Badarpur, Karimganj.
Badarpur, na? The respondent customs authorities, and more particularly the Inspector Customs Preventive Forces Badarpur, in whose possession the goods in question are lying, shall release the same forthwith upon production of a certified copy
Another
of
thing,
the.
Lordship, with regard to weight, they seized 17,200 kg.
It will আগতে কি কৈছে 17,200 and
200.
well, along with my lord truck. Along with truck, my lord.
Your truck is still there,
Truck is goods.
along with the truck.
Along with
Truck
the-
bearing number. The records which are
Along with-
produced have been returned.
I'm grateful, man. Much obliged. এই তো truck.
Yeah, please, Your Lord.
What is this?
My lordship, we are Tangia Forest Village. Yes, sir.
Ah, Fanga, no right. What right is there?
The verification, my lordship.
If you
Can we
come
do-
under the ambit of the forest, right?
My
Have you
lordship.
been recognized?
Not, my verification process has not been done till date, my lordship. Only our claim is that verification can be done. We will submit necessary document before the committee, my lordship. And if whatever happens, my lordship, the committee will decide, my lordship. So,
My lord, their entire claims are based on some departmental communications, which did not culminate in anything. Recently, my lords, in a similar issue, a coordinate bench
similarly situated, my lordship, case, my lordship.
that is simplicity, what he has provided, it's for verification, but.
Let the verification be done, my lordship, that There are several communication which I have annexed, my lord.
But you have to carry out what is given in Abdul Khalid.
Yes.
Have you carried out? Have you carried out any steps for that?
Well, in this case, my lord, what happened, it was instituted, my lord, way back in 23. This case is, my lord, 23. Abdul Khalek was the.
Maybe, but
We'll follow it,
without
we'll-
taking steps in terms with Abdul Khalid, you cannot go ahead.
My lord, we'll follow it. We'll follow.
They'll give you notice. Give whatever it is. They will look into it, park picking order. They can only evict you if you are in reserve for it, outside move. They have to segregate and find out which is the reserve forest. Not outside.
So, my lord, where, my lord, see, in the forest village,
Well, they have admitted
Kalpani,
and inside the forest,
uh,
they admitted.
Dhalchara, FB, my lord. So we are inside Dhalchara, FB extension forest, my lord. Should we have annexed some?
Now you
document?
see, if it is a forest village,
Yes, my lord, my lord.
how it has become a forest village? To become a forest village, it has to be in terms with chapter 3.
My lord.
Chapter 3 says a notification has to be issued by the forest department.
Yes, ma'am. Well, it is recognized forest village, my lord. So I have kindly see the next which I have annexed to my lord.
Where?
Because we are landless, my lord.
No,
So
landless
so-
is
so-
different.
So only we have been settled there by the department only, my lord. So,
In
kindly
fact,
see-
these documents cannot be taken into consideration at all.
36,
Page 48 and
36.
all.
page,
Huh?
page 36, one, my lord. So
Page?
kindly see page 36, my lord. So. And then page,
No. My
Thirty-
question is
my lord.
whether
It's an old forest village, my lord. So
question is you see Tongia villagers and allow them to cultivate the land already cleared from and where they have been evicted.
yes, my lord.
Local by the local eminence. This is by conservator of forest. He has written all these things. It's okay. My question, these have been taken into consideration by me in that judgment.
That's Nick Boral.
Huh?
Nick Boral.
Nick Borali, I have already taken care of all these things. These are nothing today. Unless you don't come within the ambit of the forest, you come under the Forest Reservation Act, the rights under the forest, you can very well. But
This
not on the
area-
basis of Aadhaar card, electoral
No,
votes
no, my
or
lordship,
this. But Mr.
This area
Mr.
is
Gogoi, most pertinently, a question arises as to whether within a reserve forest, there can be a forest village.
My
In
lord.
my opinion, no.
No, my lord, because the very regulation also has been interfered with by one coordinate bench, my lord.
What?
Abdul Rauf, there's a judgment, my lord.
No, that is a different thing.
But-
That is not on that. I'm not on that. I'm saying, can there be a forest village inside a reserve forest? No.
No, my lord.
You see, there are three types of forests as per the forest regulation. One is the reserve forest, one is a protected forest, one is the unclassed forest. In respect to reserve forest, there is no question of a forest village. If you see section 29 of the regulation, it says it is only in government lands there can be a forest village. So it doesn't say that it will be in respect to reserve forest, because reserve forest, the rights are already done only in terms of chapter 2. Chapter 2 only provides rights under section 12, section 13, or saved under section 21. These are the three. These writing of letters by this conservator of forest and all do not help you unless this had the sanction of the government.
my lord, page 40 also some communications I have.
No communication, this communication. But I think we close it with this thing directing you to take action as per Abdul Khalid.
Yes.
That is the only way. Now that is the law laid down by Supreme Court. They have to first identify, give you notice. After notice, everything is to be done.
Some other villages, my lordship, in the same forest village, my lordship. Some there is a
No,
panchayat also, some other
Mr.
forest
Loskar,
villages
all these
also.
things should not come in taking into account.
Verification
Abdul
has been.
Khalid now lays down the parameters. If your name is there in the Jamabandi of the forest village, you see, your names are there.
No, man. Let them verify, my
No,
lord.
but in fact,
No, they will
Because we
issue
have been
notice.
working,
Mr. Loskar, they will issue notice. You will reply. They will pass speaking orders.
because we've been doing house checks also, my lordship.
Huh?
And we have been working under the forest also, my lord. Leopard cheats also there, my lordship. We have annexed how the receipt, my lordship, house checks and the leopard cheats, my lordship.
Have they issued notice to you?
No, my lordship.
Then why are you here?
Yeah.
he wants recognition.
Let them do. The moment I pass an order, they will start issuing this as per Abdul Khalek. Do you want that?
No.
Huh? You are happy now. Be happy. Whenever it is need comes, you come over. Don't you think? Uh,
We are working under the forest, my lordship, because the leopard cheats and everything, we are giving service to the forest also.
Perhaps, my lord, he has not gone through the Nekborali judgment. I'll advise him to go through the Nekborali judgment. Then he can come again.
Don't come now. I think you withdraw. On the basis that they had made a statement on 29/7/2024 when I was taking. In addition, this court also takes note of an instruction which has been placed before this court wherein it is mentioned there is no move on the part of the respondent authorities for eviction at the Dholsara extension forest areas which falls in IRLF of Majuri range of Hailakandi forest division. In view of that, I think you should not further proceed. Heard Mr. S.B. Loskar, the learned counsel, appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the Forest Department of the Government of Assam. The petitioners, apprehending that they may be evicted from their places of abode, which are at Dholsara, Sera Extension Forest Village within Matizur Forest Range, Hailakandi Forest Division, had approached this court by filing the present petition. When the writ petition was filed, the learned coordinate bench of this court by an order dated 21/12/2023 did not issue any yeah. The instant writ petition was taken up on 29/7/2024. A statement was made that there was no move on the part of the respondent authorities for eviction at Dholsara Extension Forest areas, which falls in IRLF of Matizuri range of Hailakandi Forest Division. The learned counsel appearing on behalf of the petitioner submits that at present there is no apprehension on the part of the petitioners, taking into account that no steps have been taken then also. On the other hand, Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that in view of the judgment of the Supreme Court in the case of Abdul Khalek versus State of Assam, versus State of Assam and others reported in so and so. if steps are required to be taken, the same has to be done in accordance with the directions passed in the same judgment. The learned counsel appearing on behalf of the petitioner submits that at present, as no such steps have been taken, the petitioner would not like to pursue the instant writ petition. However, liberty may be granted if any steps for eviction are taken. Taking into account the above, the writ petition therefore stands closed. Both the writ petition, Dutati, stands closed. On withdrawal, liberty, however, is granted to the petitioner to approach this court. If speaking out orders are passed in pursuance to the judgments passed in pursuant to the directions so passed by the Supreme Court in Abdul Khalik Supra. In name orders, if any, stands to be. Abdul Khalik, citation was.
May I please, Your Lordship? Lordship, in this case, petitioner was supposed to file affidavit in reply in response to the affidavit in opposition filed by the respondent number 1. But the petitioner is in bereavement, Lordship, since last 6 June. Therefore, she is not in a position to come for filing, Lordship. Therefore, I am praying for another opportunity for filing the affidavit in reply.
What is your case?
Lordship, allotment of government land, Lordship.
Was the order dated 1/4/2022 passed by the office of the Imam and also directed to consider the approval? What is that order of 1/4? 1/4/2022, where is that? Why you are challenging this order?
Lordship, the petitioner inherited the land from her predecessor, late Jyoti Muhammad Sheikh, who purchased the land from original Khatian holder in the year 1983 and 1987. Thereafter, the land situated nearby the Mora Sampavati in Dhubri district, the land submerged, and when it reappeared, there was an encroachment, Lordship, encroachment from the seller and third party. Thereafter, but the petitioner herein are in continuous possession. Thereafter, there are 2 approaches to the revenue board. And the petitioner herein approached in this Honorable Gauhati High Court in the year 2012. And that was disposed of in the year 2016. And the Deputy Commissioner was directed to ascertain the rights of the petitioner, offering opportunity of hearing to both the parties, and also directed to relinquish if the right of any third party was created. Thereafter, the Deputy Commissioner in the year 2017, which is at page 24, Annexure 2, after offering hearing to both the parties, held that there will be an inquiry and proposal for allotment of land as per land policy.
So thereupon you applied for settlement.
Yes, Lordship.
When did you apply for settlement?
First, we applied for the settlement in the year 2010, but after passing of the order in 2016, Lordship, we again applied in 2017. Then the proposal was brought forward, Lordship, and the subdivisional.
And the SDLC had recommended.
Yes, Lordship.
Then
brought and send it to the state level committee, and state level committee issued that letter and proposed to send a proposal as per land policy 2019. The whole process was carried out according to policy 1989. And the proposal was pending since 2018 before the authority consultation.
So what is wrong with this order? You have not been granted the settlement as per the 89 policy. You don't have a right. Now the policy is 2019. Now the question is you will get as per the new policy. So what is wrong? They have rightly sent it to, and we can only ask them to expedite as per the new policy, along with the latest zonal valuation and necessary documents, information in here. So what is wrong? No case. I've read it. It has to be done as per the new policy. We don't find any ground for interference. You consider her case as per this. Now, she has already submitted all the documents. SLDC has already approved it. So now, therefore, the district commissioner had to again submit the re-proposal.
Freshly.
You submit the re-proposal after taking into account as per the land policy of area and proceed with it, because taking into account there's an admitted fact by the deputy commissioner in the order also to that effect. So do it.
Yes, Your Lordship, it's under process, Your Lordship. This settlement process is under process.
The process.
Yes, yes, Your Lordship, I've received an instruction. It will be placed before the cabinet, Your Lordship.
Please the year before that. Okay.
Telephonically, I have it.
Okay, it is under year, na?
Yes, sir.
As per the Assam land policy.
Yes, yes.
So it is there.
2019.
Huh?
2019, it will be processed.
Good. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss N. Wardlow appears on behalf of the Revenue Department of the Government of Assam. And Miss So-and-so, who appears on behalf of the respondent number 2, 3, 4, and 5. The petitioner herein is aggrieved by the order dated, by the communication dated 1/4/2022, whereby the Joint Secretary to the Government of Assam Revenue and Disaster Management Department has returned the settlement proposal of the petitioner to the Deputy Commissioner, Dhubri District, for resubmitting the proposal as per the Land Policy 2019 with the latest zonal valuation and necessary documents, information, and justification. The petitioner had challenged the said communication dated 1/4/2022 on the ground that the petitioner's recommendation was made by the recommendations were made at a time when the land policy, Assam Land Policy 1989 was in force. It is very pertinent to take note of that the land policies of the state are policy which by itself do not, are policies taken up by the state, adopted by the state for the purpose of equal and reasonable distribution of the material resources of the state. Taking into account that the Assam Land Policy of 2019 is holding the field, there cannot be a direction that this court cannot direct consideration of the case of the petitioner in terms with the policy which no longer, in terms with the Assam Land Policy of 1989, which is no longer in existence. This court also takes note of a communication which have been placed by Ms. N. Wardlow, the learned standing counsel of the Revenue and Disaster Management Department, dated 19/6/2026, issued by the Additional Secretary to the Government of Assam Revenue and Disaster (SNS) Department, wherein it is mentioned that the department is actively pursuing the matter and necessary steps are being taken to place the proposal before the cabinet at the earliest opportunity. The said communication is kept on record and marked with the letter X. In that view of the matter, as the respondents are duly taking into account, are duly taking steps for considering the case for allotment of the land to the petitioner, comma, it is the opinion of this court that no orders are necessary at this stage. It is the opinion of this court that the proceeding, the continuation of the instant proceedings is no longer necessary. Be that as it may, as the respondent authorities are duly taking up the said action steps for the purpose of allotment of land to the petitioner, the said be expedited, taking into account that the petitioner have been taking steps for seeking allotment. Since 2010.
17.
No, I only see page 24, down below. Last paragraph, the one before, and then the bigger one. Srimati Hasira Begwa and others have applied to SDC Bilasipara for allotment of land in question in the year 2010. Isn't it?
Obliged.
Mr. Viswas, your matter.
State government has filed an affidavit that they are taking this all action to trace out the vehicle which was missing from Nagaland. They reached to Nagaland, they got intimation from Nagaland from a garage, the vehicle is here. You come, the police, it will take more time. They went there, but in the meantime, vehicle is finished from the garage.
Then
The new car from Gauhati, I give it to rent, my lord. Missing, my lord.
what is to be done here?
We have prayed before the honorable court for inaction of the police, or police did not take action promptly, my lord. Other vehicle could have been traced out.
Immediate recovery of the vehicle of so and so, petitioner bearing Yodhya CJ faces number, color, artic white, bearing number PC so and so, original change to so and so. MN means it has gone to Manipur.
Yes. No, it is the Nagaland.
MN is Manipur. MN is Manipur.
That is true, but it was found in the Nagaland garage.
You'll find it everywhere. You will find it also in Delhi. Then what is happening? They are taking steps. Then why should this court monitor this system?
What is the outcome till today? I don't know. Transport, it was not recovered.
This court cannot direct. If they have not taken any action, it's a different thing. When the matter came up for consideration on Iman, and after hearing the parties, the Honorable Court direct the officer in charge to produce the updated status as to what action has been taken in so and so. In compliance to the up-to-date status being received from Iman has been placed before this court on Iman, while upon being perused the same, the Honorable Court by an order in compliance with the state direction A, B, C, D. The movement order in anticipation of the approval of the Assam Police, the following officers men so and so are hereby deputed to proceed to depose so and so. But they are taking steps. What to do?
Because they get the intimation from the garage, that's why they revive it. Well, may I be permitted
You
to
did
make-
not have an insurance.
Insurance is not paying because they are not giving final report still today.
I'll give you a final report, matter over.
Because if they give a final
Give
report,
you a
then
final, do something to the effect. It
it is
can't
a-
continue like this. Huh?
Not the FRs. They are also the revivals. They have approached the court.
that's why they revived it, man.
They have already give the final report.
The final report has to be given. You can't help it.
We have not given.
Then,
On their instance, closing we revive it.
you know. No, if the investigation is going on, you see, the role of the court as well as the role of the police are complementary. They are nothing to do with, it is not supplementary. You have made this court supplementary. Yes, to that of the police. These things cannot be, you can't take. Like, you go and with the police, they are taking few steps. Otherwise, ask the police to give the final report. You give a final report and all, finish it off. We do one thing, was thoroughly investigated and filed the final as no clue was found. However, the case will be revived if any further clue towards culprit or stolen is found. A copy of the receipt received from so and so is this. So then final report ask them to give it.
The final, that they have proceed by instance of the. We will revive it. Those are the final.
Let them give fund. It is a practice.
No, after this,
That is also we have revived.
no, you do one thing. You have to give it something. Heard Mr. S.C. Viswas, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers. One, two, five. Full stop. The petitioner herein has approached this court being agreed by the inaction on the part of the respondent number 3, 4, and 5 for carrying out necessary investigation and to take effective measures for recovery of the vehicle bearing registration number AS01PC2565 bracket original, comma MN03A7089 changed, and to give custody to the petitioner. This court has duly taken note of the affidavit which is being filed by the respondent number 3. And from the said affidavit, it is seen that the respondent authorities have taken due steps with for the purpose of recovery of the vehicle. It is a settled principle of law and has been held by the as was held by the Privy Council long back in the case of which one was a Nazir Ahmed versus Emperor, reported in AIR 1936 page 15, page 15, which have been subsequently followed by the Supreme Court in the case of S.N. Sharma. That S.N. Sharma is very nicely given. S.N. Sharma. Versus, that is AI 1970, if I'm not wrong. SN Sharma versus Bipin Kumar Tiwari reported in 1971 SCC 653. আগৰ কেছটো আছিল আগৰ কেছটো আছিল Emperor versus Khwaja Nazir Ahmed. Reported in 1945 PC 18. AIR 1945 PC 18. Wherein the Supreme Court categorically held that the power to investigate a cognizable offense is not to be interfered with by the judiciary. It is also well settled that the power to investigate it is a specific power and jurisdiction conferred upon the police authorities. And unless and until an investigation is carried out by the police officer malafide, the High Court should not issue a writ of mandamus under Article 226 of the Constitution. In the instant case, it is taken note of that the police authorities have duly carried out the investigation and taken due steps for the purpose of recovery of the vehicle. However, they have not been able to do so. Considering the above, as this court does not see any willful and deliberate attempt on the part of the respondent authorities to derail the investigation. Interference by this court under Article 2 to 6 of the Constitution does not arise. Accordingly, the instant writ petition stands disposed of, thereby directing the respondent authorities to carry out the investigation as early as possible. And if it is not possible to recover the vehicle, steps be taken in accordance with law. Otherwise, you won't get any. 20. What is it?
Yes, Lordship, this matter pertaining to excursion.
What execution?
2 lakhs, Your Lordship, as per the notification.
2 lakhs for what?
Date of the petitioner has been, Your Lordship.
1511.
Yes, Your Lordship.
That judgment. This is Surana's judgment.
Lordship.
The issue involved in the instant case. Brother, heard Mr. S.I. Akkad,
Yes.
the learned counsel appearing on behalf of the petitioner. Ms. M. Borman appears on behalf of the, you appear for the revenue. Revenue or to the petitioner has approached this court filing, being aggrieved or on account of not granting the ex gratia compensation to the petitioner. Upon the death of her husband, as per the government notification dated 15/11/2014 issued by the government of Assam, Revenue bracket Relief and Rehabilitation Branch and Disaster Management Department. The issue involved in the instant case is squarely covered by the judgment of the learned coordinate bench in the case of, what is that? What? Name?
Manisha Khatun, versus
So and so versus so and so. I passed many orders like this. Anybody has a division bench also? What have division bench?
One is
No, then what happened? One is the party with so and so. You are there finding the same. Taking into account the judgment of the learned coordinate bench in the case of Monisha Khatun versus the state of Assam and 5 others, wherein reported in reported
but that's not reported. Reported case was defined by Worship Gunalata, Passage Tapasa.
That has been reported, another reported Lucky Das sales paperwork.
Reported in 2024 4 GLT 736. And as such, now whereby the learned court bench held that to be entitled to the benefit of the notification dated 15/11/2014, the accident must be in connection with committed by extremists, terrorists, or miscreants, or accident arising out of group classes, communal violence, and ethnic violence. It was also observed that the notification dated 15/11/2014 cannot be read as if all persons suffering from any accident except hit and run case, where the offending vehicle remain unidentified in the final form of the police investigation, would become entitled to ex gratia, where other statutory remedies are available. Taking into account the above, as in the instant case, accident.
Yes, your motion. Vehicle is identified.
In the instant case, the vehicle in question was clearly identified. Offending vehicle in question was clearly identified as vehicle registration number AS 26D 4560/2020 4560, It is the opinion of this court that the petitioner herein would not be entitled to the ex gratia for which the petition stands dismissed.
So,
Made the Lordship, Madam Patel, land acquisition, my lord. Our land has been acquired, my lord, in the year 2021. Land has been acquired by the Water Resource Department for construction of dike. In the year 2021, no notices, no procedure has been followed, my lord. In fact, reply has been filed as well, my lord. That has been admitted, my lord, that it has been acquired. It is admitted, my lord. Acquired.
How? Have you paid the money? Then, have you deposited the money? This was acquired under what provision? Then, no, that means you have, means the award no pass. So if the award is not passed, how there is an acquisition? By issuance of a notice? No, it cannot be. It has to be now. The land has to be acquired freshly. You can't do that. Because if you do it, you say that, okay, 1980, I have issued this notification. This notification cannot happen like that. Because what will happen? You are going to use that rate at that point of time and pay him now. As of now, the award, you have to go as per that act, which categorically means that the provisions of what you call the Land Acquisition Act 1894 would be applicable. And if it is applicable, the procedure, then you have to have you must have done a section 6 or section 9. Section 3, it's a requisition. It is absolutely illegal. Continuing with the acquisition for all this time. There is no acquisition. No acquisition. You have to go for a fresh acquisition. What do you have out there? Dike is done. Huh? Now pay the rent for all these years and then acquire. Otherwise, no case. Done. We have filed your affidavit. So section 3. So there is no acquisition as of now. And requisition for so long is not permissible. Where is the section 9? 3. Now it will go up, much up. As of now also there is no section 6. Okay, we do one thing. We have it after vacation. We dispose it off. They are directing them to hand over the land to you. And the dike, you become the owner. Okay? You break the dike. Water Resource Department, yeah, become a headache. Okay. The petitioners herein in the two petitions are aggrieved by the action taken on behalf of the respondent authorities in depriving the petitioner of their lands without authority of law, inasmuch as without acquiring the land in question and paying the compensation to the petitioner, the respondent authorities have taken over the possession of the lands. They say they a prima facie a perusal of the materials on record and more particularly in records. This court prima facie is of the opinion that the action on the part of the respondent authorities appears to be in conflict with Article 300A of the Constitution. However, at the further, Ms. P. Chakraborty, appearing on behalf of the Water Resource Department, submits that she requires some time to obtain the instructions. List this matter on 12th of August 2026, on which date an attempt shall be made to dispose of the petition.
May it please, Your Lordship.
What it is?
Your Lordship, in this case, the respondent number 4 has constructed the building unauthorized in spite of the fact that there is a clear order from the CEO.
All affidavits have been filed.
Yes, Your Lordship, the pleadings are complete.
Okay, we have it after vacation. You are enjoying an interim order?
No, Your Lordship, there is no interim.
What is the case you are, what are you asking for?
Your Lordship, he has constructed a building illegally, Your Lordship. Please, if Your Lordship may kindly.
Who has constructed?
The respondent number 4, Your Lordship.
It has not been demolished.
No, Your Lordship.
Well,
with respect to 23.
Therefore, you don't find the GMD. Otherwise, the GMD is there. They don't dispute.
They filed their affidavit.
Oh, yes, GMDA comes. Yes, Mr. Nayak, what should we do?
So far as the, worst case is concerned, I think, Lordship, in this matter, we have already filed. And we have stated there the allegations, in the petitions are not correct now.
Not correct.
It's not correct. No further construction is going on and the building is still under silver order.
There is another petition filed by Manoj.
It's a cross, petition.
Why is he filed?
In the second case, Lordship, we have not been filed.
Somebody has sealed it.
Yes, Your Lordship.
In the first case, Lordship, it was sealed by the GMC.
The GMD authority.
Okay. Anyway, somebody has filed affidavit. You have filed.
Yes.
First case.
In the first case.
Then the second case.
The second case, yes, Your Lordship.
Second case, Lordship.
Filed my affidavit.
In the second case, you like to file a reply,
Almost.
or with the first case reply would do?
First case, the first case is the building is different. The second case.
They're two different building.
Yes, your lordship. That is why I'm saying it's a cross petition. One filed against the other, we file against it.
Oh, you have also.
Yes, your lordship. I have filed a case against the respondent number 4 that there is a.
Why nobody is appearing for the petitioner in the other case?
BP Bora.
Mr. P. Naik, the learned planning council of the JMC and JMBA seeks for some time to file the affidavit in opposition in WPC number 6752/2025. Accordingly, list this matter again on 26 August 2026. In the meantime, the affidavit in opposition be filed on behalf of the GMC or GMDA. GMDA. Yes, you have forgotten to appear.
I'm very grateful, your lordship.
But it is, this is a case, my lord, where the, my lord, accounts of the, my lord, petitioner was put up for scrutiny, my lord. That is the assessment year 2014 and 15, sometime in the year 2000, my lord. And my lord, the petitioner, he preferred the appeal before the Joint Commissioner of Taxes, who, my lord, holding that my lord, direction for scrutiny to be barred by time, my lord, allowed the appeal. My lord. When the appeal was allowed, my lord, I, my lord, followed up for the refund of my security deposit, my lord. And when, my lord, the security deposit was not given back to me, my lord, rather, my lord, the commissioner of the department filed, say, my lord, or the impugned order, which your lordship finds at page, my lord, 41, by which he says that he is not agreeable to the fact that the appeal has been dismissed, allowed, my lord, and the question of limitation would not have been made applicable, my lord, and therefore, to go for further scrutiny of the, my lord, rights.
You had a refund claim.
My lord,
Then
that was not given.
they have gone for reassessment.
They are, he is directed for reassessment.
Now, has the reassessment been done?
No.
So you have got to stay then.
Yes, madam. But the fact is whether that one, it's that the order of the Joint Commissioner of Taxes is akin to a judicial order. Now, whether by way of an administrative fiat, my lord, that judicial order can be set aside and set up not like this, my lord. It is not a refund of the TDS, my lord. It is the
Where
refund
the
of
appeal, where the appellate order?
appellate order lordship finds at page 33, my lord. Page 33. It starts from page 33 to 35, my lord.
Yes, tell me what. What type of order is this? Understood. No. The assessment order has happened. Against that, you must have filed an appeal.
No, we filed it.
He filed an appeal saying that the assessment was carried out beyond the period of limitation. And that appeal was allowed. So your assessment order goes. So once your assessment order goes, then you have the option as a commissioner, has the power to reassess, to carry, go ahead, suo motu assessment. You can do. What is this type of letters you are writing? No. Why you are writing to the deputy commissioner of state tax?
What form of work? We can do so many assessment from an order, after an order is passed by the applicant authority.
Understood. There's no quarrel with that. I don't say that you don't have the power. The requirement of passing an order of reassessment are twofold. One, that there is an what are the two words for that? One is assessment. There is an erroneous assessment which is prejudicial to the interest of the resident. These are the two requirements where you should be taking up that issue. Instead of that, you should have initiated that. Why you're writing it to the deputy commissioner and you got to stay out here now? 8 years will also go. That is 8 years.
That is 8 years.
Then, because of this stay, he's enjoying. Simple matter, 2 minutes matter. Understood, but why you're writing those letters to him? Unnecessary. And he got a stay from him. It's a simple issue. You withdraw that application, let the matter finish, go initiate whatever proceedings you feel like. If it is erroneous and prejudicial to the interest of revenue, matter over. And once you withdraw, if you withdraw that document, his reputation falls like a pack of cards.
But my lord, his problem is, my lord, that pre-deposit, my lord, he doesn't want to refund, my lord.
It is not important. That is one thing.
That is a different thing. I'm not on there. That is a refund he's asking for another aspect. Now, what is his refund he's asking for? He says here that to refund the pre-deposit amount of rupees so and so, along with so and so tilia. You initiate that, yeah. Therefore, he's been very clever to get that stay. The appellate order has been retained. Finally, there shall not be any coercive measure in terms with the notice dated so and so and so and so. What are the two notices? 30/11/2022 and 30/11/2023.
My lord, page 42 and 43.
30/11/2023. 30/11/2023. Where? 30/11. Have done notice for conducting the reassessment notice under so and so. So he is going for so you are requested to appear in person, subject to notice for reconducting a so and so in relation to an appeal order dated passed by the so and so. Whereas in consequence of an appeal passed by so and so and the order of reassessment by city letter dated so and so. How is this city letter dated so and so can be of any
Liberty may
okay, we have it after vacation. This is reminder for conducting reassessment. This is under VAT Act.
VAT Act.
Yeah.
I will book my lord, may I pass it on?
You are reopening. You are reopening the assessment, na? In turnover assessment. Where after a dealer is assessed on the 34th way of this act, any part thereof, the prescribed authority has reasons to believe that whole or any part of the area as escape assessment better has been so and so, so and so, so and so. The prescribed authority may, after giving the dealer a reasonable opportunity of being heard and after making any so and so, from the dealer and the turnover and the prescribed area shall do so. No order of assessment and reassessment shall be made after a period of 8 years from the end of the year of which a part of which the tax is assessable. Now, why you not carrying it? Now 8 years will be over. Period.
1450.
Done.
order 14 and 15. That is for the 5. It was conducted before my lord, March 2021, but it was communicated by the after. Valid that
I think the order was committed after 1 year. By the time the order was passed in, then demand was.
No, that I understand, but my question is, where any court of the tribunal passes an order in revision or demand to the effect that any tax should not be assessed under so and so, so and so, so and so by any time within 5 years from the date on. Well, let us see what can be done. This has been done under 39. Now, this is reopening. 42? Not 40. Huh? Power of reassessment is? In computing the period of limitation specified by assessment as the case may be, time during which assessment of year remains stayed under the order of a complaint shall be excluded. So now there is no stay also. No, that is the problem. You see what? See, I always tell, it is very easy for what the court does. Court says don't take coercive action. You see the implication of not to take coercive action. It seems okay, whatever maybe there's nothing up. Here there is no stay. Only court says that don't take coercive action. Means don't, after carrying out the demand, don't impose upon him and take up the money. But and you also think, okay, no coercive action, so no problem. We are one day finding. But here there's no stay. And because of that, 41 doesn't help you. 41 has to help you. Now, in a lot of GST matters, I find it, no coercive measure. That no coercive measure is also a form of an order of stay against the department, one. But the department also cannot enforce the order. You see, it has such a difficult order. Means just for example, there's a GST demand. Then no coercive action means you cannot tomorrow go ahead and ask him or impose upon or don't attach any property out there. That is okay. Till then it is okay. But in a case where proceedings have started only, you are only asking him a notice. And you are saying no coercive measure means you cannot compel him to come. See the implication of this order. That's a different thing. But you can very well ask him to come. And if he doesn't come, then take it. But this order, no coercive measure, is like an order passed, maintains status quo. Without saying what status quo.
Well, earlier there was a case, where it said that if status quo orders were passed, what is to be status quo that should have been explained. So that the person explains what is to be status quo. But in this, case, on the first day when the motion was made, the coordinate bench, had come to the finding saying that when that order itself is not there, it has been taken away in appeal. So the commissioner did not have the power to issue that letter, And under that circumstances, said that don't take any course action, And perhaps it was in the mind of the court, that to stay of final, the proceedings,
No,
it was like that.
Let me tell you. That order is not there. The assessment order is there. Assessment order merges with the appellate order.
Yes, sir.
And therefore, by virtue of merger, the assessment order is no longer in existence because of the appellate order.
Yes, sir.
Okay.
Yes.
Now, because of that, there is no assessment order.
No.
Now, what has happened is this: the authority can very well say, has the power even over the particular deputy commissioner or who has the appeals and all, to revise that because it has escaped the turnover. This power is there.
That is in section 82. That is what I had challenged. Had there been a proceeding initiated by the commissioner to come to the High Court or to challenge that finding of the deputy commissioner, it would have been a different matter. But here, on the administrative side, He, my lord, takes up that share and my lord, he says that.
No. That is
Lordship,
different.
you kindly say section 82.
No, that is again appeals to the appellate tribunal is different. I'm not on that. My question is here, the power is there under section 40.
Yes, ma'am.
The 40 power is there, turnover escaping assessment. Now here it's a case of where after a dealer is assessed under so and so, or for any part or part thereof, the prescribed authority has reasons to believe. Now,
Yes.
now let me see. Mr. Chaudhary, explain you how. You submit an assessment, self-assessment.
Ma'am.
When you submit a self-assessment or thereupon some scrutiny is done, there is a scrutiny assessment. Once the self-assessment or scrutiny assessment is being completed, then they have the power to go for reassessment. This is the power which is being exercised for the purpose of reassessment.
Yes, here it was picked up.
Okay, now this reassessment which is being carried out later on, after a particular period, is bad. Now, once that power is being, that if it is bad, you thereupon challenge it, there is a fresh assessment. So there is an assessment. There is no assessment.
Assessment is there, ma'am.
This assessment which has been made by this assessment officer is bad.
Ma'am.
But there has to be an assessment somewhere, otherwise that will remain
No,
blank.
assessment was there, my lord. Assessment was there, but thereafter this year, the returns which were submitted for this particular period, my lord, 14-15, that was picked up for scrutiny. And that was picked up for scrutiny beyond the time provided, my lord, by the statute. That is why it was said is barred.
So they have made a scrutiny assessment. Once there is a scrutiny assessment which is beyond the time, obviously what happens is the appellate authority interferes with it. So therefore that order goes. But that order which is there originally, that assessment is there, self-assessment.
Original assessment is there.
That is a self-assessment which is there. When the self-assessment is there, against that order, there is a reassessment is permissible. This is how the. Anyways, not for me to.
But
help
I will only, my lord, renew my prayer, my lord, saying, my lord, kindly, my lord, direct them to release my pre-deposit amount.
How can we?
Because that is a different, now that will be a different process altogether, my lord. But for that particular appeal, my lord, I have given the pre-deposit. That appeal has been disposed of, my lord. So why should, my lord, they keep by that pre-deposit pending, my lord, not paid?
You'll be entitled to interest.
Yes,
Huh?
ma'am.
It is not a free.
At least till now, my lord, let me get back my money. I can put it in my business. I am suffering a great hardship, my lord, for this kind of office.
Business anyway is not doing well.
But tea business is not doing well, industry is not well at all, my lord. Kindly direct, my lord, that.
Anyways, we have it after. When? You have to think about this, what is to be done. You are, because of that interim order is very dangerous. The court should have very well actually said, okay, you go ahead with the assessment, but don't make any recovery. That should have been the order. But how do you take care of the time? But anyways, I think we have to do it. Okay. List this matter again. So the matter, there's an interim order passed in the instant proceedings. And there is also a claim on the part of the petitioner for refund of certain amounts, which the petitioner was taking into account urgency being shown, this matter for final disposal on 6th of August 2026. And yes, Mr. Muni.
Legal Lordship. Lordship, I am praying for some accommodation today, my lord, as the leading counsel, Mr. P.K. Muniri, have some medical emergency in his family, my lord.
Okay, at the request of the learned counsel for the petitioner. What is this?
Well, freezing of bank account, my lord.
Freezing? How much amount? How much amount you are having? Oh, that's the only order we can pass, the lien.
That has been passed.
Then?
I don't know, Perusi ordered it as 17/12/24.
What is that? It's okay. You see, till appropriate orders are not passed, is that your 4 lakhs your amount? Unless you are showing that this amount belongs to you, then you have to go to before that particular magistrate.
Yes, correct. 102.
Then you have to go there, not here. Anyways, or is as the counsel appearing on behalf of the petitioner seeks for an accommodation, list this matter on 24th of August 2026.
Much obliged.
Police officer. The last person the court has asked to find out what is the status. So, twice tried to the mail, there are no response.
Not necessary.
Much obliged.
If he can show on the next day that that money is his, then he'll let him go there.
But the problem is that every time they come up with that order that you direction is that they can go and find out. There is a direction that you come find out that there is any proceeding with the criminal.
No. We can't do that. The bank is not the business for.
Obliged.
Yes, what is your case?
Mayor, the petitioner has been allocated government land.
What? Mango?
No, allocated government. land.
Constructed dwelling house and
certain
planted
something
trees
and-
like mango among salt. What has happened?
Worship, has been allocated with the government and with certain terms and conditions that I should be in possession of the land for 3 years, and then I have to pay the tax, and then I cannot transfer to
Who has
anyone.
done that?
The director, whatever, I was I was paying land revenue continuous. There was no any break. Director, what happened in the month of May 2022? What happened when my husband got some oral cancer, so I had to come back to the Gauhati for treatment at Nemki Hospital. So I have annexed a certificate of the after the treatment in the month of November. When I went back to my land, I found that it is completely vacant, and then somebody the government has constructed some stadium out there. After inquiry, I came to know that some person from the revenue office has come there, and then they have demolished my house and other tall trees out there. So I just pray for if
Then
there
how can we decide all these things, madam? Here, you are asking for compensation.
yes,
Go there before the civil court. How can we decide all these things? Tell me. They are not admitting. Go there. Not the
but we are
case.
saying that like there's a double land.
Anyways, what should I do? Huh?
They
You have
said-
denied.
So I need to file a
So therefore, the question you have to prove it somewhere, madam.
Sure, let me should give me some time so that I can also file and reply. against this
Okay,
affidavit.
counsel appearing on behalf of the petitioner seeks some time for filing reply to the affidavit filed by the respondent number 3. Taking into account, accordingly list this matter on 7th of September 2026. In the meantime, reply be filed on behalf of the petitioner. The counsel for the registry shall also bring on record the affidavit filed by respondent number 3. Yeah.
Right, President.
Yes.
The matters related to the land acquisition, Lordship. The Ministry of Road Transport and Highways, Lordship, issued a notification on 5th of January 2023, Lordship, for widening of the 2-lane national highway, Lordship. In this regard, Lordship, they acquired the petitioner's land, Lordship. On the last occasion, Lordship, they filed an affidavit in opposition, Lordship. Here they shows that they have acquired the land dark number 17 and dark number 20, Lordship. They are saying that these 2 darks are under belongs to Mauja Rangpur Part 2, and it is Sarkari land, Lordship. Whereas they did not mention under which part they have acquired these 2 dark land.
Are you in possession of your land?
Yes, Lordship, I'm possessor, Lordship. Yes.
So your land has not been taken.
No, I'm possessor, it's on petty land, Lordship.
They have filed an affidavit.
They filed affidavit, but they did not mention it clear, Lordship, under which patta they have acquired this land, Lordship. In the notification, Lordship, they are saying
That
that.
affidavit is
They are, Lordship.
you have filed reply?
No, Lordship, that I have received it.
Huh?
They, although they filed it,
Some additional criteria says that a part of the land covered by dark number so and so and of Moza Rangpur Part 2 are Rajya Sarkar khas land. Then what do you want?
Lordship,
They will mention patta.
Yes, patta.
How can they mention patta, Mr. Counsel? If it is a government land, there cannot be a patta.
Lordship, kindly see the page number 13, Lordship. Petition number 1 has purchased the said land in the year 2019. Yeah.
Which land?
Land, Lordship, which they have acquired, Lordship. This is the Miyadi Patta land, Lordship. You kindly come to page 13, Lordship.
30.
13, one.
No, it's okay. My question is whether your name is there in the 3A notification or not. 3D. Is it 3D?
Notification.
3A notification.
Yes, Lordship. Notification, Lordship, kindly come page 51, Lordship.
51. Whether your name is there.
There, Lordship, they have mentioned the area in hectare wide, Lordship.
My question is whether your name is there.
My name, Lordship, it's very difficult to identify there whether my land was acquired or not, but they have demarcated my land, Lordship, because the area is mentioned in hectare wide, Lordship. But my Moza.
Mr. Counsel, kindly convert the hectare in square feet. And then after that, divide it by 144. Get the lesser. And then whatever it is, get it. Okay? Take your mobile, get it done after vacation. Okay?
I may be allowed to file in reply, Lordship.
What? Representation?
Reply in affidavit.
The counsel appearing on behalf of the petitioner submits that the petitioner will file an affidavit in reply. Taking into account the above, the list this matter on 21st of August 2026. In the meantime, the affidavit in reply be filed.
I'm the.
Petitioner was convicted under section 302 of IPC, Lordship. And he is in prison for last 25 years. There is a provision for remission under BNS, Lordship, section 473. He made application.
Yes, why haven't you filed the affidavit? Why should I direct you? When a notice has been issued, whether a person is entitled to remission or not.
We have received the instruction. One meeting was convened on 22/07/2024, whereby this was rejected. We deferred by 2 years as the review board was not satisfied to recommend his release. 2 years, Lordship, most probably in July this year, Lordship, another meeting will be there.
Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner submitted that on behalf of the respondent submitted that a review meeting was held as regards the release of the petitioner sometime in the year
on 22nd of July 2024.
22nd of July 2024. And the request for the petitioner's release was rejected.
That is under check.
However,
Deferred by 2 years.
And rejected. However, it was mentioned that the question of the aspect pertaining to the petitioner's release would be taken up after 2 years. He therefore submitted that in the month of July.
It's from my side, Lordship, because after 2 years, so in July it was held in 2024. So
he therefore submitted that till July 2024, 26, the question of the petitioner being considered for any release does not arise. In that view of the matter, have you filed an application for release then? Now?
No, this order is under challenge, Lordship. These minutes has not been given to me, but the order by which it was communicated, that is under challenge. And this, prior to this, an opinion was sought from the district magistrate and also from the court which had convicted me. But in spite of that, Lordship.
Which order?
Page 49, Lord.
page 49. And it is without any reason. Reason, Lordship will see the review board has not satisfied to recommend for the release. But in respect of the
This
other,
order is there, you are, why
already
haven't you
there.
file your affidavit, Mr. Sharma? You file your affidavit.
that is, if instruction is.
The instant writ petition has been filed in the year 2025. And notice was issued on 5/3/2025. The petitioner, who has a right to be considered for remission of his sentence under section 432 of the Code of Civil Procedure 1973, had applied for his remission, which was however rejected by the order dated 24/10/2024, and thereby deferring further consideration of such application by 2 years. It is the contention of the petitioner that this right of the petitioner, the contention of the petitioner, that there is no reason why the petitioner why the review board was not satisfied. He therefore submits. It is the opinion of this court that when it is a question of liberty of a person, the respondent authority should be more. Respondent authority should bring on record their stand so that the matter can be taken up for earlier and for an expeditious disposal. Accordingly, list this matter on 17th of July 2026. In the meantime, the respondent shall file the affidavit providing the reasons as to why the impugned order dated 24/10/2024 was passed, thereby recording dissatisfaction to recommend the release of the petitioner. Yes. Huh? Yes, any urgent matters? Only council sitting. Anybody who wants to take matters? Yes. Yes, Mr. Chaudhary, what is your matter? Huh? Okay, get your dates then. Interim orders would be extended.